Yeah, I know. Ugh.
Okay, so welcome to the Deschutes County Board of Commissioners meeting for 9 a.m. Wednesday, August 16th, 2023. First item on the agenda is Pledge of Allegiance. Please join me.
To the flag of the United States of America, and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
So one note, just acknowledging that for a disclosure for the record that this past Saturday, August 12th, I was asked to attend the wildfire meeting being hosted by Senator Ron Wyden here in Bend, and I did meet him in Lapine earlier. As it turns out, Commissioner Chang was also at the meeting. Our attendance of the meeting was not pre-noticed on the Board of Commissioners website. And since issues of county were discussed, I'm just coming forward with this information so that the record for our joint attendance can be fully disclosed. I did mention it Monday afternoon, just in passing as we were doing that. So that's kind of the official statement. As I say, it wasn't predetermined, but we were at the same meeting. So at this time, citizen input for any topic that's not on the agenda. We do have a public hearing today and there's requests to speak. Is there anybody online with a raised hand feature? Okay, so seeing that, oh, sure.
Today, this morning, we see that the death toll in Maui is over 106, I believe. This is something I always worry about. I had a fire go around my house years ago and 3 people died in that fire. But when you see the destruction, what happened in Maui, I really am reaching out to all the community to please sign up for alerts. Now, I know it's not a good idea to sleep with your phone right next to you, but just in case something happens and the wind is blowing. Clearly, it's when the wind is blowing makes things all different. But this is what you can do for Deschutes County is signing up. www.deschutes.org/911. And you can sign up to receive phone calls, text messages, emails, and more based on your location. So this is for the community. We have thousands of you signed up, but there are thousands more that should sign up. And I just cannot stress it enough. You need to be aware of what's happening. Yesterday, we had a 12-acre fire that was stopped, thank goodness. But, today we're dealing probably with the worst smoke of the world. Our AQI was over 500 in Sisters last night. So, but please do sign up for messaging. It's incredibly important. You'll get the level 1, 2, 3. There's just save a life, save your neighbor's life. If your neighbor isn't tech, email savvy, whatever, just be sure and look out for other people too. So that's my message today.
So along those lines, the State Interoperability Executive Council, which is something I'm involved in, we have meetings quarterly for the state. There is an effort called Alerts and Warnings, and there's a survey being done statewide for each county to be participating, and there's a statewide system and then also county system. So Deschutes County does have these systems in place, and there's an active effort to make sure each county across the state of Oregon has this capability and capacity. So it's just good to know that it is being looked at the state level.
But what if you live in Eastern Oregon and your service is pretty spotty?
So it's being offered.
Are they going to call people? Will it dial their number with that message? Because I know I have gotten messages. I like my power company when we didn't have power for 12 hours the other day. When I called in, they actually knew who I was and they said I wouldn't have power. Mm-hmm. So, you've got to be engaged with your public safety services.
If we're talking about fire, the other thing to keep in mind is that there are the other 364 days of the year when the fire isn't burning, where we should be doing everything we can to make our homes more resilient, to implement defensible space around our homes, and to address fuel loads on the public lands and in industrial and large private forest land ownerships.
Great. Anything else? You're seeing none. So at this time, consent agenda.
So move.
Second.
Any other discussion? Seeing none, Commissioner Dare?
Yes.
Commissioner Chang?
Yes.
And Chair votes yes. At this time, item number 6, public hearing to receive testimony regarding proposed revisions to the county contracting code.
Good morning, Commissioners. Dave Doyle, County Council, for the record. Today's the time and place set for a public hearing to consider changes to the county contracting code, which generically known as the county contracting code, which is titled 2.36 and 2.37. This was primarily motivated by some changes in state law during this most recent legislative session. And as a result, the thresholds for procurement processes were raised, and internally staff thought it was probably a good time to consider raising our contracting thresholds that various department heads, county administrator, board has authority to sign for. So the code provisions we provided, and we did provide you, and it's in the packet, a red line version of it as well as a clean version, identifies what those are. One note of a change, I have a slightly revised ordinance document. We thought out of an abundance of caution and to keep things consistent that the operative date should be January 1st of 2024. That's because some of the thresholds that were increased based on the House bill, that House bill doesn't take effect until January 1st of 2024. So rather than have some portions take effect either immediately with an emergency or 90 days, we thought it was probably best for consistency to just have everything take effect January 1 of 2024. So today, after your public hearing, if you were to close the hearing and deliberate, you could certainly do first reading today if you chose to, and we'd bring it back in 2 weeks for a second reading, but then the effective date would be January 1 of 2024. I'm certainly available to answer or try to answer any particular questions you might have. Otherwise, I'd suggest that you open the public hearing, call for any comments, and proceed from there.
Thank you very much. Are there any questions? Seeing none, this is a public hearing on the matter. So this is local contracting, proposal of an ordinance. Is there anybody to speak on this matter? Is there anyone online? So we'll close the public hearing on this matter. So for discussion, raising some of the signature authorities, cleaning up the code. I noticed it talks about instead of just contracts and or change orders. So there's just kind of a clean up in the code, puts the whole package together. So
We reached out to all the various county departments, and in particular the ones that are pretty heavy into contracting and procurement. And this was a consensus from those. We vetted it with the county administrator, and I believe he may have had one-on-one discussions with the board as well. So it was mostly a cleanup effort, but I think it was triggered by the timing of I think it's Senate Bill 1047 that increased the procurement thresholds. So it just seemed like a good time to do it all. I didn't expect that there'd be any public testimony necessarily, but obviously that's our process.
this is the process. So any discussion? Are we ready for deliberation?
We did just check to see if there was any public comment, right? Okay. Happy to proceed to deliberation.
Okay. So as I say, we did have a work session on this. It has been vetted. Thank you very much for the clarification for January 1st that aligns with the state law implementation that does set these signature authorities.
It makes it a lot cleaner that way than if we have part of the code amendments effective at a different date, people
Mhm.
get confused, and it just seems like it'd be cleaner to keep it all on the 24th. And we've been operating with those signing thresholds for a lot of years. So a few more months, it wouldn't have been effective now anyway, till November, we in August. Yeah, it would have been November, would have been September. Okay.
So yeah, for deliberations, is there support for this? And then is there a motion?
Well, I'm glad you clarified that it should be effective January 1st of 24. Because I'm reading this, we need to adopt this today and adopt it by emergency. And I'm like, okay.
Yeah, that was just an option we gave you. We put in a 90-day adoption document as well as an emergency to give you folks the options. And there's some confusion in the way the enacting portion of Senate Bill 1047 is written. I mean, there's arguably an interpretation that we could have gone with to say that we could do those increased thresholds right now, but I think rather than press that issue, we were more comfortable going with the January 1st date, which is identified in that bill as well.
I just say it's important to keep in alignment with state law, and when we have to unpack something already, then we might as well clean it up. So I'm in support of these changes.
Great.
So is that a motion?
Oh,
So I move, so is the ordinance number the same or is there a different ordinance?
It's same ordinance. It's 2023-012.
So move support for ordinance number 2023-012 to be adopted effective January 1st, 2024.
And this would be first reading by title only.
First reading by title only.
Yeah, we'll bring it back in 2 weeks.
Second.
okay. Any other discussion? Seeing none, Commissioner Dare, Commissioner Chang,
Yes.
and Chair votes yes. So this is ordinance number 2023-012, an ordinance amending Title 2.36 and Title 2.37 contracting of the Deschutes County Code. Second
Thank you.
reading in 2 weeks.
We'll be back in 2 weeks.
Thank you. Item number 7, public hearing on a request to vacate a portion of Scheibel Road. This is continued from last week. Thanks for the flexibility there for the people that did testify last week. I don't know. Yeah, so we got partial testimony last week, and this is the continuation.
Morning, Commissioners. For the record, Cody Smith, County Engineer, Assistant Director, Deschutes County Road Department. As previously stated, this is the time and place for a continuation for a hearing regarding a proposed vacation of a portion of Scheibel Road. I am getting all set up here to share my screen, my presentation, and we'll get started. Are we seeing that on the other screens here?
Not yet. So, so you're logged in and presenting from your laptop?
I am.
There we are.
There it is. Okay, so real quick, just the agenda for our hearing this morning. I'm going to provide some background information and staff findings. Also going to give staff's recommendation in this matter, and then we will I'll ask the board chair to open the public hearing. Which technically has already been opened. I guess I'll ask the chair to continue the public hearing, but first here, just a more zoomed out map of the subject right away in the area. So to the west there is Highway 20. To the east is Old Ben Redmond Highway. The highlighted portion of Scheibel Road there is Scheibel Road has a branch there with a north and south alignment. The subject right away we're talking about today is that south alignment. And here's a more zoomed in map of that area. So the petitioners as abutting property owners are Jeffrey and Catherine Gates, owners of tax lot 1800 on Assessor's Map 1712-5B. Marlene Wheeler Rennie, the owner of tax lot 1901 and joint owner of tax lot 1400 on Assessor's Map 1712-5B. And Terry Rennie, joint owner of tax lot 1400 on Assessor's Map 1712-5B. Additionally, we have abutting property owners who are not petitioners in this matter. That is John Kevin O'Leary, the owner of tax lot 100 on Assessor's Map 1712-5C, which is to the south of the subject right-of-way on the map there. So Scheibel Road, the right-of-way width is 60 feet. Scheibel Road exists as a local access road, which is a public road that is not part of the county maintained road system. The road, majority of the length of the subject right-of-way contains road improvements that primarily consist of pavement of various widths. None of that meets any of our current road standards in Deschutes County Code. Road Department's understanding is those road improvements were constructed and have been maintained by the abutting underlying property owners. The public right of way was created in 1994 by dedication deed. That's deed number 1994-46818. The chief petitioners, the Gates, were one of several grantors with that right of way dedication. The Y intersection that exists within tax law 1800, the right of way for that intersection does not coincide with the as traveled roadway. To remedy this with this proposal, the chief petitioners have provided an offer to dedicate a new right of way that would coincide with the north alignment of Scheibel Road to continue to provide public access to those properties north. The proposed vacation would effectively landlock tax lot 1901, potentially depriving the owners of that property of access necessary to exercise for the exercise of their property right. The submitted petition included a loss of access consent form signed by those property owners, and those property owners were also petitioners for the vacation. So the petitioners have provided the following reasons for the proposed vacation. So I'm going to read those reasons, and I'm going to give staff responses to those reasons that were provided. So number one was invalid dedication due to restrictions and reservations. Septic was installed and permitted by Deschutes County in 1980, repaired and permitted by Deschutes County in 1991. The deed of dedication was accepted in 1994 by Deschutes County. The 60-foot width encroaches upon the septic system that was approved by Deschutes County. So road department staff's response to this item. First, the dedication of the subject portion of Scheibel Road was valid. It included a valid offer of the dedication by the owners and acceptance by the county governing body at the time of dedication. It does appear that a portion of the disposal field and reserve area for the subject property's on-site wastewater system may exist within the proposed vacation area. There are records of permits from 1980 and 1991 that exist within the property records. Additionally, it appears that an outbuilding and a portion of a livestock corral also exist within the proposed vacation area on that subject property. Staff want to note that while this situation does encumber both the public right-of-way and the underlying property, that doesn't mean that it invalidates the public road dedication that occurred in 1994. The second reason given by the petitioners, it reduces property values of the three tax lots requesting this vacation, which is 75% of the owners. The third reason given were decades-old trees and landscaping would be lost. With both these items, staff's not going to address these statements as they're not necessarily verifiable and they are not indicative of a necessity to vacate the public's interest in a property. The fourth reason given, since 1994, the county has never used, improved, nor plowed this road to our knowledge, not once that we know of as the county plowed the snow during the major snowstorms of 2017 and 2019. Staff response is road department records indicate that no county funded maintenance or improvement of the subject portion of Scheibel Road has ever occurred. However, staff would note that county funded maintenance of a local access road is forbidden under state law, and that absence of county funded maintenance is not indicative of a necessity to vacate the public's interest in a property. Reason number 5, the southern portion of the road that is requested to be vacated has not been used by the general public and has only been used as access and a driveway for tax lots 1800 and 1901. Staff's response, Mr. O'Leary, the owner of tax lot 100 on assessor's map 1712 5C, has indicated to road department staff that he has interest in using Scheibel Road for future access to his property to the south. Nonetheless, road department staff believe that generally the subject right-of-way has only been used to access tax lots 1800 and 1901 as indicated by the petitioners. The primary access to tax lot 100, Mr. O'Leary's property, is from Old Ben Redmond Highway. Here's a map noting where that access location is. Mr. O'Leary applied for a driveway access permit for that location, I believe last year, which was approved. review of aerial maps going back 20 years or more indicates that access to Old Bend Redmond Highway has existed in that location for at least 20 years and probably longer. I would also note too that can't really see it up there on the screen, but there Mr. O'Leary's property does also appear to have an access to Highway 20. Road department staff are not aware of any of the specifics regarding that access location to Highway 20 for tax lot 100. Reason number 6 given by the petitioners, traffic will increase and no traffic study has been done that we know of. And reason number 7, safety of the young children living on Scheibel Road is a concern of the parents and neighbors. Staff response to both of these is that we won't be addressing this staff won't address this statement as it is not verifiable or indicative of a necessity to vacate the public's interest in a property. Reason number 8, it is not in the general public's best interest. Obviously, Board of County Commissioners, you'll be making that determination ultimately in this matter. Number 9, induced assigned dedication under false pretenses. We were told we could remove the southern portion of the dedication with a single item deletion. Staff response, so current road department staff have no knowledge of the requirements or the circumstances under which the subject right-of-way was dedicated in 1994. I haven't found any record of this dedication coinciding or being associated with any land use approval that occurred around that time. Looking at the minutes for Board of Commissioners meetings when the deed was accepted, didn't find any indication in the minutes for any of the meetings within weeks of this that even mentioned this acceptance of this road dedication. So really not clear to road department staff why this dedication occurred back in 1994. And then again, road department staff will note that Jeffrey and Catherine Gates, the chief petitioners and owners of tax lot 1800, were one of several grantors for the 1994 dedication deed. And lastly, reason number 10, tax lot 100 to the south will not suffer loss of access as the site address of 64145 Old Bend Redmond Highway is permitted, approved, and installed. Staff's response is the primary access to tax lot 100 on Assessor's Map 1712-5C is from Old Bend Redmond Highway as previously discussed. In regards to utilities and service providers within the subject right-of-way, Avion Water and Central Electric Cooperative are both present within this right-of-way. Avion Water provided a signed consent form regarding the vacation. Consenting to the proposed vacation. Central Electric Cooperative also provided a form consenting to the vacation, but subject to the underlying property owners granting an easement for Central Electric's facilities. Central Electric has also provided road department staff, provided road department staff with indication that they have reached some type of consensus with those underlying property owners, and they now consent to the vacation. With that, road department staff findings, the proposed vacation area was dedicated to the public by dedication deed recorded at the Deschutes County's clerk's office as deed number 1994-46818 in compliance with ORS 368-326. The owners of a recorded property right that would potentially be deprived of access necessary for the exercise of that property right with the proposed vacation have consented to the proposed vacation in accordance with ORS 368.331. I do want to note with that when we're considering that deprivation of access, we're looking at properties that would otherwise be landlocked, not any property that's losing an access point where they may have other opportunities for access via other frontage to a public road. The petitioners who represent the owners of more than 60% of property abutting the subject right-of-way have submitted complete petitions and submitted the required fee. That's in accordance with ORS 368-341C, 341-3, 341-4, and 351. As the petition for vacation does not include acknowledged signatures of owners of 100% of property abutting the proposed vacation area, the vacation proceedings are subject to a public hearing, which obviously we are conducting right now in accordance with ORS 368-346. The subject right-of-way does not appear to be necessary for current or future public use. Again, it appears to only be providing access to the properties owned by the petitioners in this matter. And lastly, the subject right-of-way appears to coincide with on-site wastewater system components, an outbuilding and other private property improvements for tax lot 1800 on Assessor's Map 1712 5B, which again would encumber the right-of-way presently and certainly would encumber it for any future roadway improvements. So with all that, the road department recommends as follows. First, that the proposed vacation is in the public interest. And that the Board of County Commissioners would adopt a pending vacation order, which will be order number 2023-17, that would be subject to the owners of tax lot 1800, the Gates, executing a dedication deed for the existing as traveled north alignment of Scheibel Road that I previously highlighted. In regards to public comments, road department and the board received written comments submitted yesterday by Jeff Eager, attorney for John O'Leary. Also during our hearing last week, the board heard verbal comments that were provided by Terry and Marlene Rennie, who are both petitioners in this matter, in support of the vacation. So as we move into to continuing the actual public hearing portion of this matter, just to let everyone know if they intend to provide in-person verbal testimony today, to complete one of the blue sign-up sheets and submit that to the board's assistant. If they intend to provide remote verbal testimony, joining us online, to use the raise hand feature in the Zoom application to be called upon and promoted as a panelist. So you can do that either by pressing the raise hand button in the Zoom application, or if you're joining us by phone, you can dial in by dialing *9 on your phone. Also like to let everyone know that the board chair is instructed in regard to time allowances for people providing testimony today. There will be 10 minutes allowed for the chief petitioner and the opponent abutting landowner in this matter. 5 minutes will be allowed for the chief petitioner to provide a rebuttal, and then 3 minutes will be provided for all other testimony.
We'll do all other testimony before rebuttal, just in case there's more information.
Okay. So at this time, I'd request that the board chair continue the public hearing and call for testimony. And then after public verbal testimony has been given today, road department's requesting that the board chair close the public hearing and that the board deliberate on the road department's recommendations in this matter. With that, I'm going to stop sharing my screen and hand it back over to the board chair.
Okay, thank you very much for that introduction on the topic. So this is a public hearing on the matter, and it's a continuation. So at this time, we did receive some testimony last week, but at this time, this is the time for the applicant to be able to provide testimony. Here we go.
So kindness to pass one of each of these down. Okay, sure. Good morning. My name is Liz Dixon. I am an attorney with the law firm of Dixon Hatfield here in Bend at 400 Southwest Bluff Drive, Suite 240, 97702. I am here today to represent Chief Petitioners Jeff and Kathy Gates. Kathy Gates is here with me. Jeff is in the audience, the cowboy-looking guy back there. The matter before you is one of those that's very emotional to the people involved, as evidenced by some of the arguments you've heard today. And they're good arguments. They're just not the arguments that address the standard that you have before you to make a decision. So respectfully, I know those are all concerns to people, but I'm going to speak to what you need to look at in order to make the call. The two exhibits that I have presented to you are Exhibit 1 is an annotated tax map of your county maps, where I've taken the quarter section up above, which is the northwest quarter, and the quarter section down below, which is the southwest quarter of Section 5, and put them together so that you can see where all the properties are in the hope that it will help you understand the situation. The second exhibit that I provided to you is also something that directly from your databases. It's from your dial database. It's an aerial photograph because I find it's helpful to look at both tax maps and aerials. The Gates property is in the yellow outline up above. And if you look at it, you can kind of see where the right-of-way carves it up into 4 separate pieces. And then the piece below is the piece that's in yellow, which is respectfully to Cody, not 1 lot, but 3 owned by Mr. O'Leary, because there is both the tax lot 100 that has been identified before, but 2 additional very thin lots down below, which you can see on the tax map. The people who are in support of this application are Marlene Wheeler Rennie, which is Hollyhock 1994 Living Trust, tax lot 1901, and Terry Rennie, which is BFF LLC, tax lot 1400, which are both on the tax map that you have before you as Exhibit 1. The person who has been most vociferous against the application is Mr. O'Leary, who owns tax lot 100, which is in the second quarter down below, as you can see. I have placed X's on the tax map showing the 2 locations that, and these are approximate, where Mr. O'Leary has access already to his property. One is on the western side to US Highway 20, and one is on the eastern side to the Old Ben Redmond Highway. If you take a look at the second exhibit, you will see I've placed X's there, and those accurately reflect the white lines that show up in the aerial below. So these are probably going to be the more accurate of the 2 since they're placed specifically. Mr. Smith identified this as well in his report. The O'Leary property already has 2 accesses. Now, I don't know if the one to Highway 20 is legal. I know the one to the Old Ben Redmond Highway is because you approved it last year. That said, the standard in front of you is whether the vacation would be in the public interest. Respectfully, it doesn't really matter what it does to the Gates. It doesn't really matter what it does to the O'Learys. It doesn't really matter what it does to anybody else specifically. What matters to you is what's in the public interest. And that has changed historically. I read the road vacation cases, and they go back to the late 1800s under the old Hill laws. And what they were looking at in those days was money. Does it benefit a particular group of people in terms of making an area open to development? Does it allow a new job provider to be in the location? And so if money was there, they would dedicate a road or they would vacate a road, depending upon how the money fell. I think that's changed. I think our definition of public interest has broadened quite a bit to where now we're looking at a lot more than just money. We're looking at things like, is this the best use of the resource? Is there another thing that the resource could be used for that would be better than a road? And I think that's the issue that comes front and center here. In this case, we have a road that was dedicated approximately 3 decades ago and has never been improved, never been used by the public, never been taken advantage of in any way. So history answers the question, is it useful to the public? The answer is no. If it had been, it would have been used over the last 3 decades. In reality, we have the Gates septic system there. We have a livestock corral. We have some, the allegation made by Mr. Eager was that the Gates cut down the trees. In reality, CEC cut them down. But the point is, that road has not been used as a road ever for 30 years. It is not historically beneficial to the public, or the public would have used it. More importantly, I think what the Gates are using the property for is in the public interest, in that it is the correct use of MUA 10 property. Multi-use agricultural 10-acre property is intended for the purpose of kind of quasi-agricultural purposes. And they have placed a home there, they've got a septic system there, and they've got a livestock corral there. They do quasi-rural agricultural activities on the property, and that land serves that purpose. So what I would say is, for the Gates and the O'Leary specifically, that doesn't really matter to you. But in terms of public interest, is this the highest and best use of this property as a road that's dedicated, that's never been used? No, it's not. The best use of this property is to let it go to the MUA purpose to which it is zoned, so that it can continue to be used for that purpose. Mr. O'Leary has raised a number of arguments in his prior submittals, as well as in the one that Attorney Eager put into the record last night after 5. I got it after 5. I'm not sure when it was put in. And I think it's important to note that basically his argument is, we never should have dedicated the access to Old Bend Redmond Highway, and it was a mistake. Respectfully, I'm not sure how that applies. The fact is, the application was signed. It's in the record. I have it available to submit if you'd like to see it. And he has an access that you permitted last year. More importantly, your code in 1748-210 says you don't get to apply for a driveway permit on an arterial, which Old Bend Redmond Highway is. You don't get to apply for a driveway permit on an arterial unless you have no other access. He signed that application. He represented to you that he had no other access. So for him to come to you a year later and say, well, I do have an access, and it's this piece of Scheibel Road, he has to pick one. And in reality, by filing the application with you that he's already picked one. He's told you that he has access via Old Bend Redmond Highway. He doesn't need this access to be able to get to his road. In the interest of time, I'm going to close my comments now. I have my 5 minutes available for rebuttal, which should be more than sufficient. And I really appreciate your consideration. Kathy, do you have anything you need to say?
Thank you for your consideration. I just ask you to think about doing what is right. Thank you.
Do you have any questions for us?
Kind of a broader question I have, and maybe I should have asked Cody this, is how do we verify whether this Highway 20 access is legal or not?
Cody can answer the question. Frankly, it's not material as I see it to the facts in front of you and to the case you have to make. Even if there is no legal access to Highway 20, even if ODOT or the Oregon Highway Department never gave them a permit to access the highway, he still has access. And you permitted that in 2022. Thank you.
Thank you very much for joining us. Yep, the other party. Oh yeah, I guess I do have the request to speak here, but we'll go with the two parties and then we'll make sure if there's anybody else to speak.
Over here, Mr. Chairman.
Anywhere.
Mr. Chairman, Commissioners, thank you for your time this morning. I'm Jeff Eager. I'm an attorney for John O'Leary, who opposes the vacation of Scheibel Road. I'll talk for a little bit, and then Mr. O'Leary is going to talk for a little bit. Welcome your questions afterwards if you have any. The standard that you are to apply, there are actually two standards that you are to apply in determining whether to grant the vacation of Scheibel Road. The first is, as Ms. Dixon said, is it in the public interest to grant the vacation? We say no. Chief petitioners say yes. I'll get into that a little bit more in a moment. But there is a second criterion that would preclude you from granting the vacation, which is if you determine that the access to Mr. O'Leary's property via Scheibel Road is necessary to Mr. O'Leary's property right in his parcel. So in terms of whether it is in the public interest, chief petitioners rely primarily on the fact that the road hasn't been used in 30 years. What they are doing, to maybe use a lawyerly term, is trying to shoehorn adverse possession into the public right-of-way code. And that's not the way this is supposed to work. The Gates, the chief petitioners, applied for and received the dedication of Scheibel Road back in 1994. I have included that as an exhibit to the submission I made yesterday. And they, at some point thereafter, began just blocking the roadway. And there's a gate on one side of their roadway, or pardon me, of their property. And then there are trees that are fallen, whether by CEC or someone else, on the roadway itself, blocking access, blocking use of that roadway. And now having blocked use of the roadway, the chief petitioners are here asking you to give them the roadway that they dedicated to county taxpayers back to them. And that, we don't believe, is in the public interest. It's not in the public interest to reward a party who has chosen to block a public right-of-way that they have dedicated to the county. It's not in the public interest to try to require Mr. O'Leary to use an access from either Old Bend Redmond Highway or Highway 20, the latter of which is not a legal access point whatsoever. There's a gate on Highway 20 merely to allow fire access in an emergency. The Bend Redmond Highway access point was accidentally obtained. And yes, the application was submitted. We are not saying it was not. It was based on some false information or a false belief that Mr. O'Leary's realtor at the time had about what was required to get an address. They were trying to get an address for the listing, and in that process came to believe that they needed to apply for a driveway permit, in part because they weren't able to get to the parcel via Scheibel Road because it was blocked by chief petitioners. And furthermore, it would not be in the public interest to require the visitors to Mr. O'Leary's property to use either Highway 20 or Bend Redmond Highway, as evidenced by their names. They are highways. High rates of speed, adding another access point to either of those highways is not in the public interest. Your road staff surmised that they weren't able to tell why Scheibel Road was dedicated back in 1994, and records are incomplete about that. I would surmise, based on the map, that it likely was approved and dedicated and received by the county to provide access to Mr. O'Leary's property. It dead ends and butts into his property at the southern terminus of Scheibel Road. There, Mr. O'Leary's father reserved an easement adjacent to that access point, as though at least he was assuming that was going to be at the time the point of access to the property. And so the Scheibel Road access, giving it back to the chief petitioners at this point, just is not in the public interest. It is there for a reason. They dedicated it to the county for a reason 30 years ago. Mr. O'Leary wants to use that as an access to his property. They have blocked access to his property via that public right of way. And it's for that reason not in the public interest to vacate the roadway. Briefly, in my, with my letter, there's a map that shows an alternate possible route for Scheibel Road down the east side of Chief Petitioner's property that, that may be a less burdensome, thing for them to use rather than the kind of snake that goes through their property right now. Mr. O'Leary would be happy to work with Chief Petitioners on, and the county on moving the right of way there, if that was in the interest of Chief Petitioners and in the county. But as is with this vacation pending in front of you, it's just not in the public interest to grant that. And I'll give the rest of my time to Mr. O'Leary.
My name's John O'Leary, and I was born and raised in Bend. My parents purchased the acreage between Highway 20 and the old Bend Redmond Highway in 1959, 1960 from Ole Grubb, who was Deschutes County Commissioner at the time. And I'm against the vacation of the public road to the middle of the property known as Scheibel Road. The gates have blocked the legal entry to my property: wood, logs, tires, irrigation equipment, a trailer, and other items. Mr. Gates approached me when I was working near the entry about vacating the public right-of-way. I told Mr. Gates, my attorney said not to sign anything since it's my legal access to the property. Mr. Gates was not happy and became visibly upset and said he would not let anybody down this roadway and would block it farther up. The real estate agents felt it was necessary to get a temporary address on the old Bend Redmond Highway because of Mr. Gates' threats and to avoid any confrontation until the legal access was opened up. Shelley Ray of Ingalls and Volker went to the road department and told them of the problem we were having and wanted just an address to the property on the old Bend Redmond Highway because of the threats Mr. Gates made if anybody used the legal access. The road department gave her the forms to fill out, and she reiterated all we wanted was an address, not an access. Shelley and I filled out the forms and she took them back to the road department. Again, she reiterated to the road department that all we needed was an address and not an access because we already have a legal access to the property on Scheibel Road. I in turn called community development and asked them, okay, if I have a piece of property that borders the old Redmond Highway and I just want an address to list the property, half the property is in sagebrush, the other half is in pasture. She in turn asked me if the property is being developed. And I said, no, we park out front in an alcove and walk onto the property. She said, I can give you the address over the phone, which surprised me, but I thought that would be great. But we had already applied for that through the road department, which was a mistake. The road department never told Shelley Ray that by getting an address on the old Bend Redmond Highway, that it could eliminate your chance of getting an actual legal access down Scheibel Road. I went to the road department to talk about my legal access down Scheibel Road. The road department even admitted that Scheibel Road access is the best access to my property because you can go south, you can go east, and you can go west onto the property. And why in the world anybody is saying that I want to develop the property is completely wrong. The property, if I pass away, goes to my nephew who wants to build a house on the property. And we've had it in our family for so many years. I don't want it, if it doesn't sell as one parcel, I don't want it broken up. The road department admitted that Scheibel Road access, like I said, was the best access to my property because you can go south, east, west. However, they said, you have an access out front. And I said, we never had or wanted an access out front. We just wanted an address to avoid Gates threatening and harassing people trying to come down the access. Right now, we park in the alcove where the gate is. However, there wouldn't be a gate there But Central Electric and Ben Broadband need to get in there to go along the northeast portion of the property in the northeast corner for a transformer pole. And it's located on a rock bluff that affects all of the line going down there. Both companies have locks on the gate and do not drive down the field. To service Gates and other petitioners, they come through the gate off of Highway 26, which is not a legal access. We put that in there for emergency service. Everyone that is petitioning to this, vacate this road, should be thankful to my father who granted the service easement for the Gates and other petitioners for Ben Cable as well as Central Electric. He didn't have to do that down his property on the north end. And I thank you.
Thank you very much. So yeah, we have your written testimony also from the paperwork. So yeah, at this time, we'll ask for anybody else to testify on the matter. So I have two more. So Alfred Heston and Peggy Lee Combs.
Yes. You want me to?
Sure, anywhere. All three mics work. Yep.
Oh, okay. Do I need to stay by the microphone or?
Nope, just close. Yeah, just generally towards it.
Well, first of all, I have pictures and so forth to submit for the record. I'm Peggy Lee Combs, here to speak for John O'Leary. I have pictures about the it is a picture of the public notice that was posted for this hearing and for the application. And I wanted to point out that the notice was incorrect. It shows the roadway not going all the way to Mr. O'Leary's property when in fact it actually does. So Ruel and Francis O'Leary purchased their property in 1959, and they've lovingly cared for and improved and beautifully maintained it all these years. And of course, it's now owned by John O'Leary, their son. At some point, the people that owned the property adjacent to the north on tax lot 1800, which is now owned by the Gates, built their home on the wrong side of the property line. So Mr. O'Leary had to give up a large strip of land on their north edge so that the encroaching home could be made legal at the time. And I have a map showing that strip of land that was given up. Yellowed in on this map. And at that time, because Mr. O'Leary was giving up the strip of land for their home, Mr. Scheibel made sure the public roadway being dedicated, called Scheibel Road, did extend all the way to the O'Leary property. It was also clear that Mr. Scheibel intended this to be a public roadway because he dedicated 60 feet to the road, which is the requirement for a public roadway. He didn't give 30, 40, or 50, but a full 60-foot roadway. Now, to add insult to injury, the current owners of the property, the Gates, want to take the public roadway away from Mr. O'Leary and the public. If the county allows this to happen, in my opinion, it would be a sad day, because if it could happen to Mr. O'Leary, it could happen to anybody. The Gates purchased the property in 1994 for $105,000. And it should be noted that in 1994, you could purchase a home in Bend in town on a small lot for $120,000 or more. I know that because I purchased a home in Northeast Bend myself that year. Since the Gates's property is on about 4 acres in such a desirable location, they made a wonderful buy. And it's very likely that they would have paid a much larger amount if the roadway did not go through their property and the buildings were not so close to the property line. However, they purchased the property knowing that the road existed And it was evidently part of their purchase agreement that they would sign the dedication document, giving the roadway to the public. They did indeed sign the road dedication that very year. In fact, their signatures were the very first signatures notarized on the document.
So, yeah, we had 3-minute testimony for everybody and it's okay to go over a little bit, but let's
Oh, okay.
generally try to keep it on track here.
And I think everybody can understand why the applicationers would want to gain that property back for free, but Mr. O'Leary's done nothing to deserve this. It would be simply favoring the desire of one property over another for personal gain. They were required to give valid reasons as why to show it was in the public's best interest, and it just seemed like they couldn't find any good reasons. I'd like to point out that Mrs. Gates was a local Bend realtor for many years, a very good realtor and exceptional at her job. And since then, she's worked for a local title company. So their assertion that they dedicated the road by mistake and thought they'd be able to take it back is just couldn't be true. I think all adults know that when they sign and notarize a document, it's legal and binding. And certainly in their case, I believe that they knew that.
So, yeah, thanks for the testimony. Is that written up also? Is it written testimony that you can provide us?
Yes.
So, yeah, let's take that for the written. So, my question, it's for you and maybe for anybody else, is what did this look like? I mean, was this the historical road, the dirt road that maybe wasn't documented before 1994 for access to that area? And I don't know if anybody has the information during this public testimony.
To my knowledge, they put the roadway where it already existed.
Yeah.
So,
Okay.
and I have a copy of their road maintenance agreement. So the people there, including the Gates, certainly know that the county didn't plow or maintain that road because they have their own private road maintenance agreement. And I've included a copy of the dedication to the county and some other maps for you to review. And I've also included some photographs of where the roadway is blocked. The last thing I'd like to present is the irrigation map showing where the irrigated land is on the O'Leary property and the adjoining properties. And the front of the property is all irrigated. So that's why Mr. O'Leary doesn't like to access the property there too, is because you'd have to drive over irrigation pipe. And if anybody were to ever build a home on the property, they would build it further back on one of the rock outcroppings where it wasn't irrigated, because you can't build on top of the irrigation water. And they would want
Thank you.
to be there for a view. So
We were just trying to set a little pace for this. So thank you very much. So, Mr. Heston.
Before I start my testimony, I'd like to say I agree with you and support your previous comments regarding fire safety. My name is Alfred Heston. Thank you, commissioners, for allowing me to testify against a proposal to vacate a portion of the Shibo Road. I'm asking the board not to accept the proposal for the good of Deschutes County citizens. Keep the public road. It is in the best interest of the county not to vacate the road because of public safety and protection of citizen rights. The road department's report findings and conclusions are incorrect. They assert the main access to lot 100 is the old Bend Redmond Highway. This is incorrect. The only feasible access is Shibo Road. This point Mr. O'Leary made to Mr. Cody multiple times. To vacate the road would deprive the right of access for the exercise of his property right. There's no access from any other side that would provide the necessary access. The road department asserts it's in the best public interest to vacate the road. Nowhere in the road department's report are there any statements to support this conclusion. They do not supply any arguments why keeping the road is a negative to the county. As local access, it is no cost to the county. They do not provide any argument or finding why giving up the road benefits the county. The Scheibel Public Road benefits the county because it improves public safety by dramatically reducing fire department response time to the properties on Scheibel Road, including like lots 1901 and 1800. There are 3 gates on the property, but only one viable access point to the property. Gate 1, Mackenzie-Benz Sisters Highway. That's a fire department gate, quote unquote. It gives a fire department quicker access to the O'Leary property and the adjacent properties. Public access is unlikely because it is to be granted because it is off a state highway. Gate 2, Old Bend Redmond Highway. Quote, utility gate, company gate. The electric and cable companies use this gate to maintain the equipment which serves adjoining properties north of his property. Utility trucks are not allowed to cross the field. They only drive on rock along the highway fence. The utility companies have locks on the gate. There's a parking pad for public safety. It is not an access. The planted grass field with irrigation pipes prevents viable access from the Old Bend Redmond Highway. The irrigation pipes would be destroyed. Everybody walks. In 1903, my children, 3 and 5-year-olds, we walk from the highway. We're not allowed, even with young children, to go over there. It's not been an access. Scheibel Road. It's in the middle of property necessary for Larry to exercise his rights to access both east and west sides of the property. As has been, I'd like to reemphasize, the roads department stated it was the best place to access the property. Public safety. Fire department. The Scheibel Road access would allow quick response by the fire department. It would cut time in half because they would not have to go all the way around to the Bend Highway. They could enter gate 1 and drive across O'Leary property to gate 2. Future public use. The road is necessary for public use, especially if the property to be developed similar on how tax lots 1901, 1400, and 1800 were developed. When the declaration was granted, it was deemed necessary by the county, and nothing has changed in those years. The vacation of the Scheibel Road denies O'Leary access to a recorded property right. It would eliminate his access to an easement on tax lot 1800. This is a violation of ORS 368.331.
So I have your written comments, and as I say,
Yeah,
we're
I'm just saying thank you now.
okay. Very good. Okay, I was just
Somebody say thank you.
there. You go.
Please stop this taking which will harm Mr. O'Leary and other Deschutes County residents. Thank you, commissioners, for
Great.
your time.
Thank you. Thank you for the testimony. So those were the written requests to speak. Is there anyone else to speak on this matter? Is there anyone online? So we don't see anybody else in the room with either. Is there rebuttal on this? And then questions from the commissioners too. I can see this is, we may want to get engaged with some of this.
So kind as to pass these down. And I only have one copy of the road maintenance agreement, but I'm submitting it into the record as exhibit 6. Thank you.
Good morning, Liz Dixon again on behalf of Chief Petitioners, Jeff and Kathy Gates. A lot of new information has come into the record in the short period of time that we've had before us. I will do my best to get through it in 5 minutes. You have before you some additional submittals, but I wasn't sure if I was going to need Give you these as well. I've submitted into the records exhibits 3, 4, 5, and 6. Exhibit 3 is a development document record for Mr. O'Leary's Tax Lot 100. So you can see the total number of development permits that have been applied for the O'Leary property. The first is the driveway access in 2022, and then a legal lot of record verification immediately thereafter in 2022, and that's it. So that gives you a sense of kind of what's been developed on the property historically. Exhibit 4 is a little more complicated. It is the actual driveway access permit packet that's in your county records. And it includes in the front, the application that was submitted, including his signature. I referenced it earlier, but now you have it in the record proved. And at the very end is the code that applies, which says that he can't do that unless he has no other access, which I referenced earlier as well, but now you have it in the record. Exhibit 5 that I've provided to you is the road maintenance agreement map. And this was provided by First American Title, who Kathy works for. Got to say that up front. I don't think she bent the lines, however. And what it shows is who the property owners who are benefited and burdened by the 2004 road maintenance agreement recorded at 2004-16955, which you have before you was Exhibit 6, but I only had one copy. I apologize for that. I didn't think I'd need it. I provided it to Jeff Eager last week, so he has it as well. The road maintenance agreement is now front and center because it's been raised, and it's important because it shows who the property owners are who benefit from Scheibel Road, because Scheibel Road was put together with the road maintenance agreement in mind. These are the people who take care of it. These are the people who benefit from it. Please note, Tax Lot 100 is not on that map. It is not outlined. Tax Lot 100 is not benefited by Scheibel Road. It is not benefited by the road maintenance agreement and has no part to this process based on the road maintenance agreement that you have in front of you. All right, now to specifics. We're getting into the weeds here, and I'll try to be careful about what's pertinent and what's not to help you sift through it. But the first thing is, I want to make sure that you know that the Gates have committed that they will make all dedications and easements necessary to Deschutes County, to the Rennies, and to the utilities, so that the Rennies have access to their property, as well as Deschutes County having the ability to put that hook in to take Scheibel Road up to the north, and the utilities will be able to get in as well. And they commit to that now before you on the record. There was an argument made about notice that it was improper. There was nothing said about the notice not serving its intended purpose, that there was constructive and actual notice served to the properties involved. I don't think it's relevant, but it's a procedural issue, and so I needed to address it. The access necessary to O'Leary, they're claiming that there's a shoehorn of adverse possession here, and respectfully, I have to disagree. Adverse possession is a serious matter, and it has not been claimed, and we are not trying to assert it, nor are we trying to assert a prescriptive easement, which would be the more appropriate claim here. In reality, we're saying people are wondering if this road was used, if this road is in the public interest. For 30 years, it hasn't been used. And that's just history. That's not somebody trying to claim they have the right to claim adverse possession against the county. That's not even legal. So the point is, the gate that was referenced has been there since 1994. And yes, the Gates put it up. Yes, the Gates put up the gate. But more importantly, Scheibel knew they put it up. Scheibel approved of them putting it up. The concept was that it needed to be there. So for Mr. O'Leary to now claim that the gate is some evidence of refusing to let him use the property, the facts speak otherwise. Mr. Scheibel had no objections then. He approved of the gate, and that should be the end of the matter. There was an argument made that Highway 20 was a fire access gated thing that was never used, and that the old Bend Redmond Highway was a mistake for an address only. Respectfully, the map that I submitted into the record is Exhibit 2, and the even better map that Cody put in to the record with his remarks shows clearly that there is a worn road trail that goes out Highway 20 and goes out to the Old Redmond Highway. And those worn trails, those roads speak for themselves. They show that both are used, both work, and they exist. So
Liz, I just want to just acknowledge, I mean, we're slipping past all the times here today, and I don't want to do any procedural problems on either side. So, I mean, are we okay with how this is going today, and how do I acknowledge that legally? I just see a nodding of a head here. I just don't want a procedural problem. Okay,
I
just,
appreciate
okay,
that, Jeff.
thank you.
The Scheibel Road rationale, the way it was explained to me, and my exhibit 1 describes it pretty carefully. If you look at the tax lots in exhibit 1, you will see that those tax lots are possible because of Scheibel Road. And the idea is that Scheibel Road was put in place by Mr. Scheibel because he had a vision for development in the area. And without that road, that development could not have occurred. Most of it was to the north. Not very much of it was to the south, but the tax lot speaks for it. The tax map speaks for itself. With regard to Mr. O'Leary's specific comments, he said that a threat by Gates was made to him. Mr. Gates denies that, but more importantly, it's not relevant to the matter before you. He said that the only reason he did it was because he needed address. The roadway shows otherwise. He's using the roadway a lot. It's worn down. In conclusion, your job today is to determine if the vacation of this portion of Scheibel Road is in the public interest. We have shown you that the public has never used it for 30 years, that it serves no purpose. By freeing it up and making it available to the MUA purpose that is the underlying zoning, it allows the road and the roadway to be used in the manner in which it was intended. And we ask that this board approve it on that basis. Any questions?
Any questions or thoughts? So,
So you did say that there would be access provided to the Rennie properties.
Yes,
Yes,
they will provide an easement.
we already have that.
So will that use basically this first part of this segment of Scheibel Road that we're talking about, or will that come from a different direction?
If you look, I'm sorry, it's hard to do this when we're talking on maps, but if you look at the Y of Scheibel Road, where it comes in off Old Ben Redmond Highway, the idea is that it'll go to the north at that Y, but there will be an easement provided to tax lot 1901 that will go through 1800 in the current driveway down to 1901 so that they can get in.
So it'll come in the northeast corner of the Rennie property.
No,
No, it's more,
Gates
it's,
parking.
well, no, you're right. It's about a third of the way down the property line, the northwest property line between 1901 and 1800. You see where there is currently where the driveway currently kind of hooks over into the Rennie property.
here on this map, you can see.
Yeah.
You're talking about exhibit 1 then?
I am, or if you like, you can look at exhibit 5, which is the road maintenance agreement.
Which one is?
So-
Part of the way down.
That's this one. This is
Oh,
exhibit
that one.
5.
Okay, thank you.
So
Oh, yes.
Okay, so if you look,
So the piece of right of way that we're talking about, you would still use the first 20% of that?
maybe. Any other questions?
No questions at this time.
Will it be possible for that picture to go into the record, the big one? Okay. Okay, good. I just wanted to see it like closer.
Thank you for your consideration.
Great, thank you.
Sure, why not?
So this has been the public hearing on the matter. I want to thank the parties for being involved. And at this time, if it's the right step here, we'll close the public hearing portion of this matter. And we've got lots of good information and papers at this time. So what's the will of the board? I'm kind of digesting still myself. So
I know, I think there's a lot and there's a document that we haven't been able to see because there's not a copies.
the maintenance
I-
agreement.
I don't know, can we come back in a week and a determination then?
I also wanted to ask legal, what our what kind of requirements we have to resolve this matter and make a decision. When we hear, other kinds of quasi judicial land use matters, there's, if we don't decide, or if we decide a certain way, there's always a risk that someone will say, you interpreted your code wrong. In this case, I mean, is it similar, or I mean, and we're talking about this standard of, is this in the public's interest or not, which is a little bit unwieldy and vague as well. So I would like to understand better what what is required of us in deliberating on this issue.
And I think the opponents laid it out for you as far as there is the first component as far as whether it is in the public interest. And I think it's fairly, there's a lot of discretion, I guess, given to the board in determining that. As to the second one and whether or not it really eliminates the only access point to a particular parcel. So that would be the other factor to consider. And obviously there's been testimony on whether or not that alternative access is available for the property.
Because I have to say on there are a lot of really important concerns and interests at stake here. But to the first standard of is this in the public interest or not? Many of the concerns expressed by the applicant, by the opponent, are they're real concerns, but they are very individual concerns, and it's hard for me to kind of put the lens of is this a question of public interest or not to these matters that are extremely important to individual property owners, but I don't really have a good sense of how important they are to the general public. So there's that aspect of this. There's also this is a local access road. This is not we're not talking about pieces of the county road system, or the county owned and maintained road system. And when we talk about local access roads exist to serve certain sets of private property owners. So for many aspects of local access road decision making, what's most important is that we come up with something that's workable for the private property owners that are on that local access road. And it's again not necessarily a matter of public interest. So I'm struggling with how to think about this, and whether I even think it's appropriate for the Board of Commissioners to be the body that is trying to resolve this issue.
Well, so there is a recommendation, and I will acknowledge, as I say, we learned when we opened up the public hearing last week that, this is a hot one. And, we had people dialing in remotely as we got started. So, I want to thank everybody's participation and the recommendation from staff as a starting point for a conclusion. So, from my point of view, is there justification to go a different direction from that conclusion, just as a starting point? For deliberation. So I'm trying to get words out here so everybody can hear this also. Do you support bringing this back, I guess, is kind of the step right now, or do you have some clarity for deliberations?
There's part of me that would prefer to send this back to this set of landowners to try to sort something out amongst themselves, and for us not to continue to hear this or to go to deliberations on this. But that's part of why I was asking whether what our obligation is in proceeding with this process. But also if it's our responsibility to reach a conclusion on this, then I could go to, if it's our responsibility to reach a conclusion on this, then I am comfortable going to deliberations now or next week.
Board Chair, if I may.
Sure.
Just kind of to answer or to respond to what Commissioner Chair is saying. Under ORS 368, 356, ultimately, I'm just going to read it to you. So after considering matters presented under ORS 368, 346 and 368, 351, the county governing body shall determine whether a vacation of the property is in the public interest and shall enter an order or resolution granting or denying the vacation of property. So in response to what you're saying, ultimately the board does need to deliberate on this and does need to make a ruling.
And I'm sure, yeah, both parties want clarity on this and we'd be the decision body on that. That's so thoughts about proceeding with deliberations now or studying
I
it more?
prefer next week. I actually tried to help solve an issue in my neighborhood a couple of months ago.
Yeah.
And I found it was incredibly difficult. So, just as
Okay.
a mediator, I do have a question though, Cody. The Gates property without all the easements through it, is that like a 10-acre piece where that easement, where the road goes through? I mean, I'm just looking at Miss Dixon's exhibit number 2. And I'm just wondering.
Commissioner, off the top of my head, I don't know the exact acreage of their property, gross or net acreage. They might be able to answer that question for you right now, but
Okay, well,
I could get that information for you certainly, but
Miss
Yeah,
Dixon-
now let's get the information.
We can enter into the record that the title company has determined that it would be 5.6 acres if that part of the road were vacated,
5.6.
approximately.
Okay, so that's for everybody's information. Is there another comment? Okay, so very good. Okay, so I support digesting this a little bit, bringing it back, and we've acknowledged that a decision will be made by this body, putting direction to this matter.
But I mean, there's a lot of history amongst these landowners who are parties to this this issue, and I'm not a legal expert, but it does seem like in some settings, giving people direction that they need to mediate something is appropriate, and is there any mechanism like that in this situation?
Not for this type of process.
Okay.
So deliberations will be in 1 week on this matter. I want to thank everybody for bringing it to us and sharing the information. A lot of paperwork associated with it. So we'll do our homework and bring this back. Sure. Hearing is closed. Yeah, so hearing is closed on the matter, so no more input. So that's what I was kind of referring to, is the fact that the paper provided today and the testimony provided today and last week will be the content of this matter in front of the board. So thank you very much. Sorry we didn't get to a decision today, but now we have a good feel for what's going on here. At this time, item number 8. This is a proposed first reading of ordinance number, or an ordinance for a Griffin Plan Amendment and zone change. Okay, welcome.
Hello, good morning, commissioners. For the record, Rachel Vickers, Associate Planner with the Community Development Department. The item before us today is a first reading for an ordinance that would be approving a plan amendment and zone change for a 40-acre property east of Bend. The file reference number is 247-22-000-792-PA, 793-ZC. The application is to rezone the property from exclusive farm use to multiple use agricultural and a concurrent change in the comprehensive plan designation from agricultural to rural residential exception area. The first required hearing was held before a hearings officer who recommended an approval to the board, and the board had their public hearing on May 31st and commenced deliberations on June 26th. At the conclusion of the deliberations, the board voted to unanimously approve this application. Staff and legal counsel then prepared the materials in front of you today. The ordinance and exhibits were created to best represent everything in the record and the outcome of the board deliberations. In your packet is a draft of ordinance 2023-018 with exhibits. These materials have been reviewed by planning staff as well as legal counsel. And today's meeting is the first reading, and I will come back in 2 weeks on August 30th for a second reading. Now, concluding this summary, staff is available for questions. And if there are not any questions, the board may approve the ordinance as written.
Thank you very much. Any thoughts or proposals, edits, or a motion?
Okay, I just have a question because we approved this on the 26th of June, you said?
Yes.
But it's taken like almost 2 months to come back then?
The 26th of June.
That's what you,
Oh, yes, sorry, deliberations. Yeah, just with staff schedules, it took a bit to get this back in front of the board.
okay,
Well, no, we didn't have a board meeting during the fair and everything, so just finding a place for it.
I know.
Mhm.
All right. I know, that fair, darn it.
No, it's good. We fit it all in.
It's a little busy, doesn't it? Anyway, okay, thank you for that.
Mhm.
Now I can approve the first reading of ordinance number 2023-018 by title only.
So that's a motion.
Yes.
Second.
Any other discussion? Seeing none, Commissioner Dare,
Yes.
Commissioner Chang,
Yes.
and Chair will vote yes. So this is the first reading of ordinance number 2023-018. An ordinance amending Deschutes County Code Title 23, the Deschutes County Comprehensive Plan, to change the comprehensive plan map designated for certain property from agriculture to rural residential exception area, and amending Deschutes County Code Title 18, the Deschutes County zoning map, to change the zone designation for certain property from exclusive farm use to multiple use agriculture. Second reading in 2 weeks.
Great, thank you.
Thank you. Item number 9, deliberations. This was a remand of LBNW plan amendment and zone change. These are some. Okay.
Oh, yes, something that's a little bigger.
I have one extra copy if anyone needs another one for any reason. Sorry, just still getting set up here a little bit. Good morning, Commissioners. For the record, Tarek Rawlings. I'm the Senior Transportation Planner with the Community Development Department. Before you today is the deliberations for the LBNW LLC Plan Amendment Zone Change Proposal. Application number 247-21-000-881-PA and 882-ZC. Those are the original file numbers. This is a remand procedure. And the remand file number filed this year is 247-23-000-398-A. And this relates to essentially a plan amendment zone change from the existing zone district of exclusive farm use and the comp plan designation of agricultural to the zoning designation and comp plan designation of rural industrial. This was following a public hearing a number of weeks back. And so this was basically prepared a decision matrix that should look somewhat familiar in terms of the formatting for how we reviewed deliberation issue areas. It's a fairly large one. There's 10 pages or so there. Starts on page 128 of your packet there. And if there were no initial questions, again, this is, the board's clarified that the scope of this remand, including the deliberations, are limited to the issue areas that were raised by on appeal by the Land Use Board of Appeals, or LUBA, otherwise known as. And you've had, the record is provided to you in this web link that's kind of throughout the memo and throughout a lot of these procedures and materials. And so if there were any initial questions, I'd be happy to entertain those right now. Otherwise, we could start going down the matrix list just through the issue areas.
So I'd like to just take some time and kind of think big picture here about what this is. So this was an approval for a comp plan change and zone change from EFU to rural industrial.
Correct.
And now it's come back on remand saying the EC analysis. So did we do an EC analysis or not before? As in, we didn't even get to that. So I got it all in front of me, but I just want to kind of work through.
Yeah, and that will come up in one of the issues areas at least, but we do have an existing EC Goal 5 inventory that we currently rely on. It's from 1994, but
yeah, so not for this specific application. That was kind of my thought process just now. So I'm just thinking about what an EC is and how does it pop up in this situation. So we have something we rely upon, and we talk about a quarter mile on each side of the center line of the road.
Right. And
Landscape management zone is what we're talking about here.
And exactly, the remanded issue dealt with Goal 5, which is specifically related to the county's Goal 5 scenic resources. So exactly what you're describing, sort of the scenic corridors on either side of, in this case, Highway 97, which is recognized as a scenic highway. And a lot of that is the landscape management combining zone that you're referring to. That's what the current scenic resources are inventoried within, not necessarily that zone, but the EC analysis that supports that zone.
You're saying 1992 EC analysis?
92 EC analysis, excuse me, I might have said 94 originally, but it was 92 originally.
Yes, it was, according to the letter.
So,
Right.
So that's in place. And then having that EC analysis in place says you shall use muted colors and fencing, and there's some requirements that are fit into that.
Correct. Our current EC analysis has a program to meet the goal, which includes a number of mitigation measures related to scenic resources in this instance.
So then on the remand, the applicant provided a kind of a more site-specific EC analysis.
Related more certainly to the site, and we'll get into that in terms of what they've defined as the impact area. There's also it's their addressing of the new uses that may be added, which is also going to be addressed in the matrix. So in this case, they'd be adding industrial uses to this area that was inventoried in 1992 that may not have specifically addressed those uses. And so that's what most, if not all, of what LUBA was remanding us on for that decision.
So then the EC analysis kind of starting point that was provided during our public testimony, I just talked about cell towers and concrete facilities. And now in the written record from this, there's a much more detailed or expanded EC analysis.
Absolutely. They revised considerably and added a lot more detail, a lot more line item review of each of the potential uses, the conflicting uses, so to speak. They went back several times to their consultant and then worked internally to really address kind of any of the issues that were brought up around that analysis, how adequate it was, how it was identifying some of the key components within that law. And ultimately, that is largely what was remanded by LUBA, was compliance with an administrative rule related to that EC analysis, essentially.
So then the EC analysis is kind of analyzing a future state, as in there hasn't been a conditional use application for any of those things, but now we're looking at what if.
Correct.
Out into the future. And there is a current building there, and there's current, commercial activity. And I even noticed there's a privacy fence, I think, has popped up over there too. So yeah. Just trying to understand, because as I say, this matrix is kind of a mind bender. That's really what I'm concluding. I try, studying it. I'm like, man, I need to be grounded before I even look at some of these things.
I would agree with your characterization of the matrix. And so we have legal counsel and our planning manager here if there's any questions on the nuance. This was something we had to really very heavily and very closely work with the applicant on in order to get this in front of you. So if there's any question whatsoever, we're here to clarify any nuance.
And that's
there.
good information. So applicant kind of worked through this process because they're the prevailing party and we're working in a remand. So the applicant's even been involved with this matrix.
We've discussed a lot of these points, and so this is really as reflective as we
Points of
can
it,
get
yeah.
of the applicant's position, I think. At this point, it's all based on record, but it's really something we've tried a lot to coordinate with the applicant on, so.
Okay.
Yeah,
I just wanted to kind of think the big picture here before we get going into it.
of course.
Any other thoughts or questions?
Well, I went back and reviewed their original letter from the 23rd of June. Yeah, that was one of my other questions. I was like, oh my gosh, okay. Yes, it would be really lovely if we could get this size initially instead of getting the teeny ones, because then I could actually transfer my notes.
Sure.
I don't know if that's possible, but maybe Brenda it is, because it's like a waste of paper. We get the teeny ones, but then thank you for this.
Sure.
As someone who likes to highlight.
Sure.
Okay, well, let's work through a matrix and as I say, we'll see where we go with this.
Okay. Sure, without further ado, the first issue area, and I'll mostly just try to like reiterate the issue area. If there's any need for clarification on what the board's decision point is, I'd be happy to kind of read that initially, but I'm just going to kind of give as much space and time as you might need to deliberate on these issue areas. So issue area number 1, as you see on the first page of your matrix there, is does LUBA's remand require the county to conduct an analysis beyond considering the economic, social, environmental, and energy consequences of allowing uses under the rural industrial zone that differ from the uses currently allowed under the EFU zone on the subject properties? And that is a really long way of asking whether the scope of this the opponent has characterized this scope of the Goal 5 inquiry as broad, and the applicant disagrees with that characterization. And so this is asking whether the board thinks that there needs to be analysis outside of the EC requirement or EC considerations. And really the central question is, does the board agree with the applicant's testimony suggesting that LUBA's remand does not require more than an analysis considering the EC consequences of allowing uses under the rural industrial zone?
So yeah, setting direction to this is, I mean, it's just tricky. This is a tricky one. So, I mean, because the question even says, what do we think LUBA was thinking? I mean, it's kind of a weird question up front.
I agree. I think it's a discussion over whether this is broad or narrow. There's really no other input than that, I would say, other than the broad the applicant has characterized as applying to the EC analysis and the EC scope. It's a kind of a wordsmithing issue area thing, I would say, for lack of a better term. And looks like legal counsel's here if you do have any other.
Right. Stephanie Marshall, Assistant Legal Counsel. And I appreciate some of the initial questions that Chair DeBonne had as we get into this. The intent of presenting these thinly sliced issues is to make as clear a record as possible to support whatever decision the board comes to. Because, anticipating that this might be appealed again, rather than having a remand, again, whatever the board decides, we want the record to show that each of the issues raised by LUBA and raised by the opponent and responded to by the applicant have been fully digested and considered by the board. So with that being said, this first issue is presented for the board to have a response on the opponent's argument that the broad inquiry means something beyond environmental, social, economic, and energy consequences. Does broad inquiry mean you're considering something outside of that? Or does broad inquiry mean that you have fully considered in a broad way each of the ESEE consequences? Again, fully recognizing and acknowledging that, these issues we've tried, I believe staff has tried to boil these down in a way that are digestible, and yet also responsive to the issues that have been put forth to the board in the testimony, and in the record.
So, oh, go ahead, please.
Is there a geographic dimension to broad as we're talking about it right now? I mean, are we, especially if we're talking about scenic impacts, right? Are there scenic impacts within, what you can see just from as you're driving by at 55 miles an hour on the highway, or are there scenic impacts more broadly, kind of at the landscape scale?
Thank you, Commissioner Chang, for that question. I would submit that question is later in the matrix. This really has to do when you reference just now scenic impacts. What is the scope of scenic impacts disregarding how broad of the impact area? What impacts are we talking about? Are we talking about economic, social, environmental, and energy impacts only? Or is the requirement that the board consider something beyond those impacts? That is the initial question that we're asking in this issue 1, or that has been presented, not that we're asking, that the opponent has suggested there's something, when considering impacts, it's not just environmental, social, economic, and energy.
And does that set aside the question of how good our 30-year-old EC analysis is today in 2023?
That's a later question. This really just is what analysis need be made when you're looking at the broad inquiry. Is the board within, does the board believe that, or not believe?
Else needs to be.
Right, exactly. Does the board agree with the opponent's arguments, or does the board believe that the remand is limited to a consideration of economic? It's going to be hard for me to go through each of those 4, but I believe that, I'm trying to pinpoint those considerations. Is there something beyond those considerations? ESEE. Is there something beyond those considerations that the board needs to make? Putting aside for now the question of the impact area and the question of how well analysis might have been done in the 1990s. It's just, what is the board considering? What is a proper consideration under this component?
So, the point would, I support the fact that EC is the tool. It's the vehicle we analyze these things. Very inclusive statements by saying those 4 aspects, because that could include anything anyway. So I don't support going past the EC analysis. So it's good discussion here today. Which means yes.
Yes.
The board finds that the proposal does not require analysis beyond economic, social, environmental, and energy.
I think EC, those 4 things adequately capture the scope of what we should be considering.
We did it. We got through the first one.
Well, yes, I did say yes.
Okay,
already.
perfect.
Yes.
Very good. Thank you. All right. Thank you, Stephanie, for.
I'm just going to be doing my best here as well.
Well, it helped when you say thin slices too.
Yes.
Yes. As I say, you look at the big picture and then you study a part of it and then you look at the big picture and like, oh, how are we going to get clarity on this?
Tarek, when was a solar farm approved on Highway 97?
That was Cindy Smith did that one. I want to say it was like 2010 or 11,
Okay.
something like that. Do you know when this? We can look it up, but I think it was
That's just a
offhand.
side note. I just,
Yeah.
you know, we're talking in landscape and
Right, that one, it was around 20 to 10 to 2012, I want to say, but I could find out.
Water in those trees, right?
they're not.
Oh.
'Cause I look at them every time I drive.
I've
by.
always noticed
One
Oh,
thing
what
we
is
ask
a
is
couple of red trees out there, yeah.
Yeah, no, they definitely need some water.
If we're all good on issue area number 1, I might
all in agreement.
proceed to 2. Yeah, thank you for the clear direction on issue 1. So just to frame issue number 2, the question is before the board, is the county required to amend or modify its goal 5 scenic view inventory under Oregon Administrative Rule 660-023-0030? Or may the county rely on the existing inventory set forth in the comprehensive plan? This relates a little bit to what we talked about with how we have an existing inventory included in the comp plan that we currently rely on for certain.
So when we say inventory, I think of, you know, things on a shelf maybe. Is the item landscape management at that point when the word inventory?
I believe it's referring to the actual scenic resources. So in this case, it would be the scenic resource within, you know, that buffer zone around a scenic highway. So they're trying to inventory those sensitive or otherwise kind of protected resources in order to create a program to meet the goal 5 protections around those
So
resources.
then we're talking, the goal 5 scenic view inventory as applied everywhere, not just between Bend and Redmond then.
Well, and the scenic part is just a portion of that larger goal 5 inventory, also includes wildlife considered.
Well, that's fine.
Exactly. Just wanted to clarify that last piece.
Okay.
When was the last time that this inventory was updated?
It would be 1992. We're still using that 1992 inventory.
So, and this is an open legal question? I mean, because that's how.
If I may, Stephanie Marshall, again, this question is presented for deliberations to respond to opponent testimony. So this is a question that's been raised by opponents, which is why it's presented as a decision point for the board. The opponent argues that the county needs to address OAR 660-023-0030, which is the inventory process. Commissioner Chair DeBonne mentioned inventory as being items on shelves. These are the goal 5 resources again, this is another thin slice of the onion. You know, what resources is the county looking to protect? And then the next step down would be, how does the county protect that? But are there additional resources? Is there additional items to be added to the county's inventory? Is the county required to revisit its inventory of goal 5 resources? And in this case, it's the scenic resource that was identified as a resource to be protected back in 1992.
So then I would conclude that this is part of our comprehensive plan, the big picture, when we put on a work plan annually through our community development department and the planning commission. You know, someday we'll open it up and, you know, look for edits and things we want to add or subtract or whatever. But I wouldn't put it as part of this application is the conclusion I would come to, if that's answering this question.
Yeah, it does. It sounds like you would answer yes to that question, potentially, it sounds like you would be comfortable relying on the existing inventory, if I heard that correctly.
I think you did.
So that's I mean, I'm just trying to put it in the big picture because this would be something we would do, but it's not because of this application.
And Commissioner Adair, that was a 2015 land use decision for the solar
It
farm.
was
Yes.
2015. Okay.
Right.
Where's the water?
Your thoughts?
Thank you.
I would say that the landscape has changed dramatically since 1992, and I don't think using a 1992 scenic resource inventory is adequate.
But with the application, somebody's specific, comprehensive plan and zone request trigger us to stop and do that project?
Well, the question is, the high level question is, or the high level questions are about whether this application has substantial impacts on Goal 5 scenic resources. And if we don't even have an adequate inventory of scenic resources, then we can't answer that question. That's just the way I see it.
So, so we want to keep this 2-1. Is that how you're saying no? And I think you concluded yes.
I said yes.
Okay.
And,
We don't have to keep it 2-1. You can decide that
Well, no, I gave my
my
conclusion.
interpretation is appropriate and you want to.
Yeah, that could, yeah, that's
you can
possible.
Go with me.
Yeah.
So,
Well, as I say, I mean, I explained how I saw this, there is a time and a place for that and it's the bigger picture. So that I come to the conclusion of yes. Yeah.
Very good. Yeah, I've noted. Thank you for the clear direction.
there are rules that will apply to lessening the visual impact, I believe, from what I've.
Through the LM zone and things
Yes.
like that. Exactly. Yeah.
Right.
It would be.
We do have rules.
We do for some of the scenic resources. Exactly. If that was really helpful for issue area 2. Thank you for the direction. We could move on to issue area 3 if there's no further question. And seeing none, I'll just read the issue area here. Are the conflicting uses identified pursuant to OAR 660-023-0040 subsection 2, those uses allowed under the rural industrial zone that are not allowed under the EFU zone? This is an attempt to identify cleanly the conflicting uses that are required to be identified through the EC process. The opponent more or less argues that there were not adequately identified conflicting uses. There weren't specifics on which ones were inadequate, but it was saying that the EC analysis was inadequate in part because of these conflicting uses not being necessarily well defined or identified. As Chair Dare or Commissioner Dare noted, there was some revisions that were put into, or both of you had mentioned, there were revisions put into the EC analysis that were made an attempt to address each of the line item rural industrial uses as conflicting uses. And so kind of with all that information, the main question, again, just related to the actual identification of conflicting uses is, does the board agree with the applicant's testimony that the county complied with that OAR provision, OAR 660-023-0040, which is the EC decision process, by considering as conflicting uses those uses allowed under the RI zone that are not otherwise allowed under the current EFU zone?
So this kind of gets the substance of the matter, referring to, would there be any conditional use as a rural industrial use that would trigger denial? I guess I'm just thinking of, the outcome of this because of that. I mean, as I say, I rely on the fact that conditional use is going to be a public process and it is in an LM zone, so it'll be acknowledged up front and it'll be mitigated as per our rules. So, I mean, I don't know how far we want to go with that.
Chair DeBonne,
If that help, yeah. I'm just trying to use words so we can respond to it too.
Yes. And I appreciate that. I actually would observe that you might be a step ahead.
Thank you.
This
Thin slices.
These are very thinly sliced.
Yep,
You can see
good,
through
thank
them. This is really the question of what are conflicting uses, and are there additional conflicting uses that need to be analyzed beyond those that would be allowed outright or conditionally in the RI zone that are not currently allowed outright or conditionally in the EFU zone. So those we know are conflicting uses. Does the board find that there are more conflicting uses out there? I'm kind of almost speaking in, less formal wordsmithing here, just because, these decision points are very dense. So the decision point is it essentially, is the board finding that that universe of conflicting uses are those uses that could now be allowed on the property that could not have previously been allowed under the EFU zone?
So,
And,
okay,
and is
yeah,
there a
so
broader
I see what
universe?
You're saying, so
Yeah.
it being a half a step ahead is referring to
Right,
the body of things that fit in those new zones,
yeah,
fitting under an EC. Is there anything else?
right.
Yeah, and I would conclude that there isn't. I mean, we've got a pretty tight system here already.
If I understand correctly, the basis for Aluba's remand to us really is about goal 5 scenic resources. I mean, when we first heard this application, I have all sorts of concerns about the way that we're thinking about agricultural land. But it seems like that is outside the scope of what Luba has asked us to talk about. So I think those, within those parameters, I think we are looking at the appropriate potential conflicting uses.
And I would agree, yes, there's definitely a lot of conflicting uses out there. So.
Sure.
I mean,
So it sounds
looking at
like,
the-
oh, excuse me, sorry. didn't-
No, just looking at the work from the original, the applicant from June, reading what they presented.
Sure. So it sounds, unless I'm mistaken, there's three votes saying that they agree with the applicant's consideration of the conflicting uses.
Yes.
All right. Very good. Thank you so much, commissioners. We'll move on to issue number 4A. This is sort of broken out into 3 subsections, mostly related to, again, the EC review process and how the EC decision process and different steps within that. So 4A here is what does the county identify as the impact area pursuant to Oregon Administrative Rule 660-023-0040 subsection 3. This is related to the identification of conflicting uses, in that this is sort of a second or a subsequent step in that EC decision process where where the applicant would have to identify the impact area. The impact area in this case has been identified by the applicant as an area that includes all the properties west of Highway 97 within the landscape management combining zone between the 61st Street intersection and then the Tumaload Road off ramp. And so that's been what they've identified as the actual impact area. So that's what's before the board really is, do you agree with the applicant's defined and identified impact area, which is that the properties west of 97 and the
And then
60.
opponent's testimony says the impact area must be larger than the 3 subject properties. So do they kind of both say the same thing?
It was, so the applicant responded to many of the opponent's original testimony. You'll see that the opponent's new testimony is almost, I think all of it is from their new evidence and testimony, but was presented as part of the public hearing. So the applicant still had a rebuttal period after that to address some of these original concerns. So I do believe that that within the revised EC analysis put forward by the applicant, they really tried to respond to this comment from the opponent and try to define the impact area a little more clearly. And that's what they landed on.
Because I drive on that highway a lot and people are definitely not going 55. You can be driving 65 and people will pass you like you are going backwards. So yeah, widening that area, what they've done from 61st to Tumalo Road seems to make sense.
Sure.
So the way that the applicant's EC thoughts are now framed is broader in scope than those 3 properties.
Correct. That the defined impact area is larger than
These
those
2.
3.
Everything west of Highway 97, like for miles and miles and miles, or
Zone, which is that.
Right, in the LM combining
the
zone, and then still even then between the 61st Street intersection and the Tumalo Road off ramp.
Okay.
That's the kind of the east-west parameters of that.
got it. Okay.
So the applicant's proposed impact area is that west side in the LM zone. And so I would conclude yes.
Yeah, I would say yes as well.
And then is this, this will be, is that precedent setting, I guess, is my, when I think about this, does that mean something in the big picture of the world for other applicants or not?
I would
Well,
maybe point ask Lee.
yeah,
this is such a a fact-specific determination that the board is making in the context of this application and this analysis on this goal 5 resource in this area. You know,
Somebody will refer to it
yeah.
someday, but
possibly,
yeah.
but really you're looking at the impacts on this goal 5 resource of this proposed rezone and comprehensive plan. So
you confirm yes on that.
Yes.
Also.
I was just.
I
gonna
did
thank
already.
you. I appreciate
That was
it.
4A.
That was 4A. Yeah, thank you very much for the clarification. We'll move into 4B next. So related to, again, the EC decision process. 4B, issue area 4B is there a distinction between EC consequences and the impact area such that consequences may be documented outside of the identified impact area? So this is fairly nuanced in that we've now just identified and agreed with the applicant's impact area. And they've produced analysis that shows EC consequences. So potentially things that may result from this proposal being granted approval, but that they contend that there is a differentiation between this impact area and maybe consequences that are outside of that defined boundary we just went over. And they want there to be clear. They want there to be clarification essentially in the record that you can have analysis related to EC consequences outside of that impact area, even though you've defined an impact area on through a different process or different step, essentially.
So they want it in the record that there can be consequences outside of the impact area, and that's okay. Or that it was appropriate for them to analyze those consequences outside the impact area.
And that, okay.
Okay. I mean, I would want to make sure that the analysis. Okay, so we're talking about both the scope and the adequacy of the analysis, right? So I might have concerns that the EC look that they've done outside the impact area does not adequately address the cumulative impacts on scenic resources in our community.
Exactly.
But that,
So if I have those concerns,
in a later question.
if I have those concerns, I should answer yes to this, that it's good to look outside the impact area.
That's a good way to ask that question.
Okay. Okay. My answer is yes.
Which is that scenario of land and elevation, seeing somebody's rooftop, of you can't see the mountains. I mean, there's some scenarios that were written up in the record there that they were talking about.
This is largely, I think, responsive to those exact pieces you're referring to.
So I would conclude yes also.
Okay.
Yes.
All right. Thank you very much, commissioners. All right, moving right along to issue area 4C. This issue area is, can the identified impact area be amended at a later proceeding to match the EC analysis? The applicant believes that you can amend the impact area, or excuse me, that the impact area of their analysis can be amended in an iterative manner at a later date. So that's the position of the applicant. There's not really any oppositional comments related to this particular issue area. But if the impact area needed to be adjusted for any reason, they're seeking clarification from the board on whether the board believes that is possible at a later date or not.
So then help me understand. I mean, are we talking about the county's 1992 Goal 5 EC analysis, or are we talking about something about this specific application?
It would be this, current
This
one,
EC.
current EC analysis.
When you say this EC, do we have an EC associated with this application now?
We do.
And remember, that was my question. Did we have one this whole time, or now we have to create one because of this remand?
We had to create one.
Yeah. So as I said, I just wanted to be crystal clear on this. So it was 92. And then when we create a new EC for this, are they in conjunction with each other? Or does it override the 92 one for this specific application?
Typically, an EC analysis is prepared when a county or, county or city is looking to determine what development regulations might be required in order to protect a Goal 5 resource, whether it's a scenic resource or any other type of Goal 5 resource. And the EC analysis also informs a local government as to whether to allow a use completely, not allow a use entirely, or allow the use in a limited way. So those three questions on this application is informed by this EC analysis.
Okay. And then now I'm thinking the big picture here. So this is a remand from Land Use Board of Appeals. If we come to a conclusion here, does it get reviewed by LUBA, or could it be accepted locally if it's not appealed?
If it's not appealed, it becomes final.
So remand comes back. We say, okay, well, let's edit it. Let's come to a different final state of this decision. And that could be the final answer on this land use application.
Correct.
But then both parties somebody could appeal it still.
Correct.
Okay, thank you.
So what are the chances that it's going to come back again then?
Well,
Who knows,
I
right?
mean, we don't, yeah, we're going to put a nice,
Fall?
we're going to put a nice package together, very business-like.
Probably,
Yes.
yes.
No, we're gonna. Okay, so then the second note under applicant testimony for 4C, it talks about staff notes. The OAR states that local governments are not required to follow 4 steps in concluding an EC analysis sequentially. Are we referring to the 4 aspects of energy, social, environment, or are we, what is the 4 steps?
That's more, I would believe, like
Yeah.
identifying the conflicting uses, impact area, the third and fourth.
Yeah, this
defining
is
the-
actually,
Okay, so it's
if you
kind
go
of the
back
table
up
of an EC talking about,
collecting information about the resources, determining the adequacy of the information, determining the significance of the resource sites, adopting a list of, okay, that's actually not even the impact area part of it.
but that, okay.
So if we don't have to follow that sequentially,
Right.
then
You
it's
can
okay
revisit
to
it.
Go back and revisit the impact area.
That's the question.
Is it possible? Under what circumstances could an applicant come back and dramatically shrink the impact area?
Well, the board's decision on this application is informed by the EC analysis that the applicant prepared. And part of that reason is because when the original EC analysis was done in the early 90s, the possibility of RI zoning on this parcel was not considered because it was not in existence. That is really the main reason why the board is going through this process of considering all this information to have a better informed decision and then to make findings and conclusions supporting that decision, which we will have those decision points coming up. And because LUBA said there were not enough findings to support a decision based on Goal 5 impacts. That's why this is back to the board. I'm not sure I'm answering the question.
So we're really only considering, I mean, what we might anticipate is that we will only see people who are seeking to expand in the impact area.
I think
Or
it's
the-
just, can it be amended later? I mean, I don't think that it's specific to expanding or contracting. but it seems to me that if you've got a pool of impact area that's being considered, shrinking it doesn't really change that. And now, the fact that that analysis has been made, expanding it would be additional analysis.
I support that EC is a tool for decision making, and that would lead me to the conclusion that an iterative manner. I mean, because if the tool doesn't work, let's update the tool to make sure we have everything included. So that would get me to yes on this also.
It may be amended. Yes.
Very good. And it could go anyway, any direction.
That's part of my concern.
Well, but I mean, it's a tool for us as decision makers to put on paper, the applicant and everybody's got opinions about it, but it's to put it on paper. And then decisions are made.
I'm not prepared to give a yes or a no on this question.
So we'll go with, 2 yeses, but I mean, if there's more discussion, that's fine also.
Thank you very much, commissioners. All right, and moving on to about the halfway mark here. Issue 5.
Stephanie, we'll be a little bit longer, but we'll get to you after this. That's the next agenda item. Just one person though, so we're good. It's not a room full.
Well, thank you very much, commissioners and Stephanie. So issue number 5A is, does the county accept and adopt as its own the applicant's updated EC analysis as appropriately documenting the economic, social, environmental, and energy consequences of allowing or prohibiting the conflicting uses on the subject properties? This is getting at what, we've talked a lot about the EC analysis itself, and this is getting at whether the board accepts the most recent revised version of that EC as their own. Should this be approved, or even just for uses of relying on the EC analysis?
So I looked at it online. I didn't print it out. It get to be a pretty big document at that point.
Right.
So I guess that's the starting point. So as I say, why I say that is because if there's a specific use or if there's any words in there to be debated, that we could go that deep right now, because this is proposing to adopt that document as part of this decision.
Absolutely.
I think that there are a whole lot of allowable uses within the rural industrial zone, and I'm not comfortable that the applicant has parsed apart the kinds of impacts that each of those different allowable uses would have.
Stephanie, is there any more insight you have on this one?
Well, I wouldn't make any comment because I'm intentionally not stepping into your role as weighers of the evidence. I would just, my only comment would be in deciding this point, is there additional analysis? Does the board believe that there's more analysis that should have been done in the updated EC analysis the applicant prepared? And would note that there was an objection originally by the opponent that they were all grouped together in ways that was not particularly helpful or perhaps not compliant with.
You mean the first response to the Luber remand?
Right.
And is it, because it not expanded drastically after that.
So that's the question before the board is essentially if the board decides yes, accept and adopt the updated EC analysis, that would be a decision that the EC analysis does appropriately document the economic, social, energy, and energy environmental consequences of allowing or disallowing. Again, the EC does not make you make a decision on that last question to allow or prohibit. Does the board adopt that updated EC analysis as the document on which it will consider in making that decision later in this matrix?
So a couple thoughts. I'm gonna go back to a big picture when we're driving between Bend and Redmond, right? I mean, you just did
I
that
do
too.
it, yeah, a lot.
So this was a rural exclusive farm use zone parcel with a small footprint of water and other open space on the property. Part of farming is you could have a large hay shed and equipment rolling around, making dust, doing things. So then I think of, right now when you drive by, it's a large building with, newer equipment for sale, agricultural based equipment. So I kind of see it down the same path. Now we're analyzing what else could, conditional uses could be, which gets me back to the vision of a goal 5 scenic resource. So when I think of that, when you're driving between Bend and Redmond or the other way, we're probably not going to see corporate towers or apartment buildings and parking lots. We're not going to see, the corporate headquarters of some big company there. So, I mean, we're already kind of putting it down the path, rural industrial. And yes, it may be, things on wheels rolling around, or, something at some height, but we're not going down the path of, a car dealership. I guess I should be careful about what could happen there, but, I'm just thinking, we're not going to be big signs, big flashy, balloon guys rolling around out there. Maybe that could happen too. But, I'm just saying we're already doing a lot of good things to keep it kind of more agricultural, industrial, welcoming.
There's a pretty wide,
Yeah, so I mean, that's why I had to stop
You haven't
myself.
mentioned some of them, but there's a wide array of things that are allowable uses in the rural industrial zone.
So as I said, that's why I was just trying to, it's probably not going to be a multi-story glass building, corporate parking lot thing. It's going to be more Central Oregon style. And we also have, the conditional uses have been reviewed over the years about what a rural industrial, and this is evolving. Rural industrial is evolving because of having a rural industrial in that corridor.
I don't think you can say that. I don't think you can say that there's not going to be large buildings with lots of parking unless you look down the list of allowable uses in the rural industrial.
Oh, yeah, no, I agree with that. I agree.
Specifically,
Yeah,
specifically
I was referring
say-
to the vision of what I'm thinking. Yeah, so I understand what you're saying.
I mean, there's what you can imagine, right? And there's what you can expect, and then there's what's an allowable use under the rural industrial zone. And there's a lot of things that are allowed under the rural industrial zone that are pretty visually impactful.
Well, as I say, I'm just trying to, kind of use words again, so you understand where I'm coming from, or the world understands where I'm coming from as we make these decisions. So, okay, we were at what, 5B? Sorry about that.
We're still on 5A.
We're on
5A, okay, yeah.
so.
And I think it sounds like Commissioner Chang has
Yeah, okay.
clarified that he would answer no to that, and that the EC was not adequate, if I'm not mistaken.
I don't accept their analysis as ours.
Okay.
So any thoughts, Commissioner?
Well, it is theirs. And there are a lot of things when you drive down 97 in that area. So, I look at the Crane Company and then I look at the goat farm. So, I mean, you've got so much divergence there. Hard to call it.
Well, so then, I almost might propose that we scroll through it. I mean, which would probably take an hour or something, but scroll through it as part of deliberations. Maybe we're not going to get landed on this, because for me to accept that is to say I've reviewed it and I looked at it, but I didn't look at each line item and digest each piece. It is kind of a big step to say, okay, what they've proposed is our decision.
One more note, which is set forth in the decision point on this issue. Staff notes that the standard for an acceptable EC analysis is set forth in 660-023-00401, which states the EC analysis need not be lengthy or complex, but should enable reviewers to gain a clear understanding of the conflicts and the consequences to be expected. So the question is, does this EC analysis enable you as the reviewers, as the decision makers, to have a clear understanding of conflicts and consequences?
So, I kind of conclude that I'd like to review it more. I mean, and maybe it's,
Do we have time? We do have time to review it, correct?
We are on a pretty tight timeline on this one. It's got 120-day remand deadline, which we are right up against the end of, just
Well,
with
and I'm
first and
thinking-
second reading and.
possibly reconvene this afternoon after more, because now I kind of want to go into that specifically.
Could do it during lunch.
Yeah, however the board would like to proceed.
I would like to do that. I mean, now, because I say now is this, when I started, I said this is a brain bender. Now I've gotten through to this point, and now it puts it in more perspective.
Right. So yeah, we have one kind of motion for no, that not accepting the EC consequence or the EC analysis, and then it sounds like there's two votes to kind of bring this back at a later today.
Well, I want to study more,
Sure.
which means notice.
At 1 p.m.
Yeah, whatever.
Well, we'll see. Can we proceed down the matrix with?
Certainly we can. So there's
Without
two
accepting.
sub questions for sub question 5 that relate to, or excuse me, it's just two sub questions. So there's only one other one related to the EC analysis, which is the next issue area, which was that does the applicant's updated EC analysis address the opponent's objection that conflicting uses were inappropriately grouped together? If you needed
Yeah,
to
I would
review the
make that
analysis for that as well. Sure.
I'll come back for that one too.
Okay, so we'll come back on 5A and 5B later this afternoon. That'll bring us to,
Proposal. We'll see if we get there, but I think, yeah,
sure.
start out with that concept.
And then moving on to issue area 6A. This is also a very big, high ranging question in terms of sort of overall approvability of this application or this remanded process. The issue is, does the board wish to allow in a limited way, or prohibit conflicting uses under OAR 660-023-0040 subsection 5? The applicant recommends that the board decide to allow the conflicting uses fully, and then the opponent has asked to prohibit fully. There has been no proposal on either side for a limiting option. And that's pretty much all that's been in record for those three choices related to this OAR provision.
So when the proposal is to allow conflicted uses fully, it sounds like a pretty shocking statement in this context of what we're talking about. But allow conflicting uses fully in a landscape management zone, Goal 5 resource area with requirements of setbacks, color schemes, vegetation, all that, right? I mean, so I'm just putting, it's kind of steps back a half a step from doing whatever you want there to doing it in the landscape management zone with requirements.
That's true. Those requirements would still be in place on the property.
We were just talking about the long list of allowable uses in the rural industrial zone. If we chose to go in a limited way here, could we either say certain of those allowable uses in the rural industrial zone would not be allowed, or could we put kind of significant conditions on some of those uses that are much more visually impactful?
And I think
I'm gonna have Will,
I will.
just because I'm tired of talking, I'll have Will fresh voice.
Rose, your planning manager. I wanted to clarify, there's something unusual in this structure that is that you're seeing in the matrix. And Stephanie, jump in if I'm not getting it quite right. But what the applicant has asked you to do is to find that there are no protections required for visual resources associated with the development.
Hmm.
Because if you're identifying protection measures, you would then be coming in the EC analysis. Remember, you're allowing, limiting, or prohibiting. And so the applicant has asked you to allow it outright. Opponents have asked you to basically prohibit the uses. And so to the extent that the landscape management zone remains on the property, which it does, the applicant hasn't proposed to remove it. It is not the program by which visual resources are protected on this property. It continues to incidentally be there. And it's an important distinction because to the extent the board says, I believe that, and Stephanie, jump in if I've got this right. To the extent the board says that, that we believe that that this use would have visual impacts and we are relying on the landscape management zone to mitigate those impacts, that's a different decision than the applicant's asking. The applicant's instead saying that there are no requirements to mitigate these impacts, but, the LM zone will remain.
Yeah.
And is not, it's not a moving piece in this decision. So really important subtlety there about how the decision is structured.
And then is that the justification because it's a juniper sloped area up to visual housing and there's no mountain views? I mean, I'm just thinking back to what I've read here. Is that the justification?
Of the applicant's argument?
Yeah.
That there's relatively limited view shed at this point. And that, when you're doing an EC analysis, of course, the board's welcome to choose anything. You're being asked to balance economic opportunity, use of the property versus this visual resource. And so it would be possible for you, even if there were significant impacts in your mind, to say the economic opportunity is more important. And the applicant's argument is that there's limited visual resources to protect and that moreover, the economic opportunity outweighs those as you weigh those in the EC analysis so significantly that you would allow those uses without any additional protections rather than impose some specific limitations on them.
Then are we getting down to the fact that, I mean, as I say, this is a narrower parcel with a juniper slope behind it and the edge of the house roof is and no mountain view, because just north of there is a big open green pivot with mountain views right behind it. That would be a whole different scenario than this.
Yes, site specific.
So, okay, well, that helps too. So then 6A is it a site specific question and answer? I mean, is this for this decision?
Right.
Allow conflicting uses fully, which is what the applicant's asking for.
And that's actually changing their position from their letter.
They originally had stated to support a limiting option in addition to the fully allow, but they've now urged the board not consider the limiting option in response to the opponent's arguments. And the opponent has said that it's all or nothing. Well, they didn't say it's all. They say it's nothing. Just to be clear. Right. But this is a very site-specific analysis. So when you're considering the Goal 5 resource, which is the scenic view from Highway 97, what that view is over that other property with the pivots and all is, will approval of potential approval of future RA uses on this parcel change that view from Highway 97. It's again, there's lots of slices to this onion, but the Goal 5 resource that was inventoried and is sought to be protected is the scenic view from Highway 97, that view corridor.
And so if we were to accept the applicant's preference recommendation here, are we setting a precedent for other property owners who want to do a conversion from EFU to rural industrial to ask for the same thing? Essentially to say, yeah, the landscape management zone exists, but it just doesn't mean anything.
In that instance, if the landscape management zone appropriately was applied to protect that resource, across that property, which that's the reason why it's back here, is because we have the LM zone protections, but those were not considered on this property because it was not one of the pockets of RI zoned properties. And maybe I'll have Will jump in and try to rephrase what I'm saying. It's not a wholesale, like anybody can now say LM zone doesn't apply. That's what I'm advising. This instance here, where impacts of zoning property, rural industrial on the scenic resource along Highway 97 were not originally considered on this parcel of property because those RA zones were in pockets. So I don't know if there's nothing in the record to my knowledge as to how many other properties could benefit from a decision in the applicant's favor to allow fully. I don't know that information is in the record, and so I could not speak.
It's
Yeah,
that specific info is not in the record, like which, what parameters might fit this type of an approval. I don't think this is necessarily like a cookie cutter type of analysis. You could really cleanly apply to any other even groupings of properties that would be site specific, to the point where I think even the EC would have to be substantially different depending on one property to the other. That would be my takeaway, is that this might provide some sort of an example for someone maybe interested in applying for a rural industrial zone change, but that it would be so site specific. They would largely have to redo the whole EC analysis to reflect the history and the surrounding properties and the site itself.
And I would also second that, that this, if someone came forward with another similar application, you would again have an EC before you being asked to weigh the relative merits of the visual impacts versus the economic opportunity. There's a variety of other considerations, social, but I think those are the headlines.
Mhm.
The other thing I want to try to state again, because it took me a while to get my head around this, is the relationship between this proposal and the LM zone. And it's really pretty unusual. I'm going to say it again and see if it resonates. And ask some questions. Is the applicant is asking you in a silo. So we're going to take the LM zone and we're going to put it over here for a second. We're going to forget it exists. The applicant's asking you in a silo for this application in this EC, are there visual protections that are necessary for the traveling public with regard to these properties? And their argument is that you should conclude that in fact no protections are appropriate or required because of the economic opportunity and other considerations are so significant. Once you make that decision, then you can come back and note that the landscape management zone isn't being asked to be removed from this property. It continues to exist on this property, it will continue to apply. So were you to make that decision, the landscape management zone would, someone came in for a building permit, for example, would be subject to all the requirements that the landscape management zone applies on structures in that zone. But it's strange because the EC language is written a very particular way, and you're being asked to make a decision in a silo that doesn't rely on the landscape management zone, but also in the end, knowing that it continues to have some applicability. So you have to decide,
right,
without those protections, you have to say, that this property needs the development on this property should be subject to no visual protections. And then at a later step, you get to note that, well, there actually are visual protections, but you have to make that decision in this easy process in a silo. It's pretty unusual. And one of the, the difficulties that you're finding yourself in here is you've got, of course, an applicant who'd like you to allow this outright. You've got an opponent who'd like to see you deny it. And the record has not been built for the questions that you're asking in some important ways, or what a limit option looks like. If you're going to say particular uses might need particular protections, that's something that, that typically you would need a record. You'd need a record to go through and build. Yeah. And you'd need to do that type of review. And at this point, it's not there, and the calendars are very tight.
Any thoughts?
It would support a limited option.
Well, I will acknowledge that it puts us in that same situation of wanting to answer the question of, if somebody came in for a conditional use, how are we going to stop them up in the process before it even happens? It always kind of ties me in a knot, thinking, let's not go analyze something that might happen in the future and say no before it even happens. So I always worry about that. And as I say, there's a vision about what could or should happen out there, and landscape management zone is going to be a part of any specific, building, structure, development, conditional use. So I'm hesitant to answer this right now until I go back and study that EC to, figure out if there's any parts and pieces of that I want to, edit or whatever we're going to do.
I hate when you say it's in a silo. Yeah. Just seems inappropriate. I mean, to me, visualization in our county with all the millions of people that drive up and down Highway 97, we have to be aware of it, and you could tell it really hasn't been followed too much.
So your support kind of.
I want to come, I would
on
like
that
to,
one,
yeah,
so.
wait.
Well, on that one, sure.
Yeah, exactly what Will said. Decision in a silo. No.
This next issue, area 6B, is very similar. So if there needed to be, if we needed to come back on this one, this is related to more or less what Commissioner Chang just decided. And if there was a limited option to be chosen, does the board wish to continue applying that landscape management combining zone to the subject properties? If you feel comfortable deliberating on this, be happy to listen to any questions or anything, but we could also bring it back if that's the preference for the board.
Well, so this conflicts, it makes my head hurt a little bit. So let's get back to what Will said. So if we do, in 6A, allowing conflicting uses fully, landscape management zone requirements would still show up when somebody comes in for a building permit. So then the next question, it says, the board wish to continue applying the LM combining zone to the subject properties, ? So help me resolve that.
This says if the board answered no to matrix issue 6A. So if you answered yes, you can skip.
All the way to 7.
But if we answer yes, I'm living in a world there, you come in for a building permit and it's still required.
Right.
On 6A even.
6A would be, if you were to say fully, allow it fully, then this question of should it be limited or how would it be limited wouldn't.
Yeah, no, but I mean, I'm working my way back to 6A again. So
Right.
saying the words allowing conflicting uses fully means the full list of conditional and outright uses are available for somebody to come in and ask for, correct?
Correct.
And then once they go for a building permit, they're still going to have to follow landscape management zoning requirements.
Correct.
The color of the building, the fencing, and some trees or whatever.
Setbacks and things.
So then, as I say, that now you look at 6B, it asks the question, do we still apply it? We would still apply it either way, I think.
I think I understand this. And again, the difficulty here comes out of the structure of the statutory scheme.
Right.
For the EC language. I think the way I understand this is that the applicant's asking you to do this outright because in the statutory scheme, that's the relatively clean thing to do in terms of this. But what the matrix is then asking is if you'd say, no, we do not feel comfortable allowing this outright and, relying on
All uses.
because we're not relying on the landscape management. So we actually do have concerns about the visual impacts. And we do want to balance those against the economic opportunity by limiting some options. The matrix at this point is saying, if you said, no, you're not ready to allow it outright, it's asking you, would you like to point to the landscape management zone, basically import that program into this process as the basis for providing those protections? And then finally, you can see the kind of the structure 6C says, if it's not the landscape management zone, it's something else. Would you like to basically build your own protections in step
Okay.
and build sort of a specific landscape management zone for these particular properties, something that's really specific to the industrial uses, the visual characteristics, and build something in particular. the difficulty that likely would come out of that, and Stephanie can weigh in here, is that, there isn't one built in the record at this point.
Yeah.
And
Mhm.
I don't know if it'd be very difficult to build one in
Yeah.
short order, and I don't know if we could build one outside of their, a hearing record process. So,
So we might work our way back
Mhm.
by concluding that no is going to be the answer. I would conclude no would be the answer on 6C.
Mhm.
But I'm not, sure where I'm going to go with the other two yet at this point.
I think the pivot there is the 6A is, if the 6A is yes, then, you can move, you don't have to worry about 6B.
Mhm.
If you
Yeah.
have visual concerns at 6A, then the question is, do you want to use the existing LM zone as the
Yeah.
program to protect that?
And so as I say, this all start to fall in place after I go study the, as I say, the final arguments EC, which is very expanded, but now it matters a lot more to me now that we've gone through some of this.
Yes, yes.
But for 6A, we support a limiting option. It doesn't mean we have to custom build a set of conditions.
Yeah, so if in 6A you say that you don't want to allow it outright, and that you do want to, and you don't want to prohibit it outright, but in fact you want to provide some limitations, that leads you into 6B and C, which is either use the LM zone as it exists today as those protections, or to build a custom one in 6C.
I would agree. It doesn't sound like we have time to build something custom, and frankly, for one application, I don't think that's a efficient use of CDD staff time resources.
So let's not quite make a decision on that, but it's helping seeing where this is going to go now.
Right.
No, we have to be thankful then that we have the LM zone that we can import in.
Does it sound like we want to bring back all 6A, 6B, and 6C in the afternoon? I mean, one leads to the other.
5 and 6, it looks like, right?
5 and 6, exactly. Sure, we can bring the whole thing back. It's got a ripple effect, as you've sort of noted.
Yeah, so let's go through 7 and 8 and
Sure.
just because now it's getting a little bit more clear, but now
I appreciate your patience. Yeah.
Yeah.
So just skipping ahead to issue area 7A, this is on page 9 of your decision matrix. Oh, sure.
I think that the rest of these all
Depend on your.
Yeah, whether you said, allow or prohibit or limit.
So they're all going to fit into the
Yeah.
reconvening.
These will all be, 5 through
That's
8 will
fine.
be in the afternoon.
That's good.
Okay.
So we'll start at 5 then?
We will begin at 5A, in the afternoon when you're ready for us to come back.
Oh.
So as I say, the proposal is that we, get through the next agenda item and then reconvene in this deliberation this afternoon. So is 1 o'clock or 1:30 or 2 o'clock more appropriate? Just second timing.
What do you think?
Well, depending on how long it.
I mean, like a little bit longer then. So 1:30 or 2 is what I would.
1:30 would be probably okay.
How about 1:30?
1:30 sounds good.
Okay. Thank you for the flexibility on this. As I say, I was doing my homework and I was like, oh, I knew I was a little lost even. Yeah.
You've done really well. Thank you, commissioners. Appreciate it.
Okay.
See you at 1:30 then. Appreciate your time. Thank you.
So at this time, item number 10, thanks for your flexibility. 2023 Spay and Neuter Grant Program Award recommendations.
All right, good morning, commissioners. For the record, Stephanie Robinson, Administrative Analyst. I'm here this morning seeking board direction on final grant award determinations for the 2023 Spay and Neuter Grant Program. This program is offered to nonprofit organizations who provide spay and neuter services in Deschutes County for pets whose owners are unable to access or afford the procedure. And in June, the board approved a total of $10,000 in funds for this year's spay and neuter grant program. We opened a grant application period from late June to mid-July, and the county received 4 applications from Companion Animal Medical Project, Embers Wildflower Animal Sanctuary and Bunny Rescue, Furry Friends Foundation, and Street Dog Hero. Once we received those applications, they were reviewed and scored by our dog board. Their scores were averaged to form a recommendation to the board on the disbursement of grant funds. And a summary of the funding recommendations was included in the meeting packet. And then I also provided each of you with a copy of the applications. So I can turn it over to you to discuss, or I can go through each application and the award amount, whichever you would like.
4 applicants, 4 different ways. Any thoughts, or you want to study this more, or just approve it? Or
We're not talking about a lot of money here,
Yeah.
so I don't think we need to deliberate a ton on this.
let's accept recommendation.
I just have a question about, I think it was Street Dog Hero. They had a net loss last year, maybe $50,000, but it's all at Warm Springs. So that's underwritten by somebody.
That's interesting. I know they go out to Warm Springs 1 or 2 times a year to provide free spay and neuter procedures. So that might just, I don't know, come out of grant funds, or they are going to use some of these grant funds for that program this year.
Okay, I mean, I just
But
was,
in Warm Springs or in Deschutes County, that's. I think Street Dog Hero is a great organization, but you know, I know them first as an organization that is importing dogs to our community, not as an organization that is trying to limit, undesired, population increase of dogs among, within the community already. So I just have a lot of questions about how they would kind of compartmentalize funding so that it was used, in Deschutes County to address, essentially population control of dogs in Deschutes County already, as opposed to importing more dogs from, all over the, globally.
So I guess in their application, so they did just create or install a clinic space in their Bend location, and they plan to offer once a month 20 slots per clinic for spay and neuter procedures. Some will be no cost and some will be low cost. And these funds would support that once a month too.
So yeah, I mean, for that amount of money, this is just going to help.
Yeah,
Any small effort is going to be.
It's not a lot of money. It does raise questions about, well, if they weren't able to compartmentalize to kind of serve Deschutes County, then should we be allocating more money to one of the other projects instead?
that was a
the main
question.
reason.
Yeah.
That's the main reason I raised that question.
Commissioner Dare, did you have anything else?
No, I just had seen their, significant loss. And I was just, their operating loss, and I was wondering if they could continue. So, we can definitely keep that in mind for next year and see, hopefully things have turned around financially for their bottom line.
Well, and I want to thank the dog board for reviewing this and coming up with a recommendation. What's the true up for general fund? Did you?
Yeah, so general fund is funding $5,905.
More than that. Okay.
Yep. And then the donations made when residents register or license their pets was $4,095.
So I move recommendations based on the dog boards awarding the 2023 spay and neuter grants to the program applicants.
Second. Any other discussion? Seeing none, Commissioner Dare,
Yes.
Commissioner Chang,
Yes.
and Chair votes yes.
And thank you for the orange file.
Oh, you're welcome. Thank you.
Thank you, Stephanie.
I mean, I guess, so the concerns, questions I raised, kind of like how do they compartmentalize, how they make sure that, this is going to benefit, benefit Deschutes County, help us control, unwanted dog populations in Deschutes County. Maybe they could you would just convey that to them, that I had those concerns, and if they want to respond, I'd be interested to hear what assurances they can give us too.
Perfect. I'll do that. Yes, thanks.
Other items?
Actually, just
Follow up. Okay.
Commissioners, for the record, Whitney Hale, Deputy County Administrator. I think, and Stephanie, you can correct me if I'm wrong, but we could, if the board wanted to, sort of make that part of the grant agreement that funds would be used for procedures or occurring in Deschutes County. And I think that if that was problematic, we could also look at adjusting the grant amount if they felt like that was too many funds to perform procedures here locally. So if that's of interest to the board, it's certainly something we could look at through the grant agreement process.
Our dog is being neutered as we speak, and the
Today's the
estimate
day, huh?
for Jake, I was like, really, Bob? Anyway, the quotes for neutering, $500 to $800. I mean, unbelievable. So how far is $2,600 going to go?
So, I mean, I'm not too strong about it just because of the smaller amounts. If it was anything larger, we'd go for it.
Yeah.
Okay.
So no need to worry about it.
Sounds good. Thank you.
But thank you for,
Other items? Anything specific?
Not at this time. There may be one after the last agenda item today.
I'm thinking we're done with our regular agenda here. So you're saying after our deliberations this afternoon?
Yeah, Peter might have an update after CDD
which is
related
fine.
after
Okay.
that item.
So for clarity, I talked about it earlier, and I'm going to go speak at the Redmond Rotary, and there's a request, to talk about the east side of Redmond. And, I've been kind of a proponent of maybe there's a thing out there, could be called the long-term visitor area. Is there opposition or support? I mean, I'm not trying to be controversial here. I'm talking about ideas. So is there clarity?
Today was, if it's your idea and you want to present it as your idea, that all power to you.
I actually got an email this morning from Mayor Fitch, and we're going to have a conversation tomorrow, I believe, before the meeting, just talking about the 45 acres and what we have out there. So
it might boil down to, for clarity for us as a board, would that 45 acre, and we maybe have kind of done this, would that 45 acres be available for something? As I say, it's just ideas at this point. Or do we want to hold on to it for other purposes? And maybe we're not ready for that decision, because, I've been at the Oasis Huddle meetings, and I've been up in Redmond talking to folks. We've committed to 10 acres, which turned into 12 acres, which now we have a lease agreement on. So we have, and we want to do a land swap. I think, there's the support for just doing a land swap, which means DSL is asking us to, not have unsanctioned campers and have it cleaned up. So then is that 45 acres available for, part of this whole thing or not?
Possibly.
Yeah, so, and we can probably just leave it there at this time. As I say, it's just ideas. It's the discussion. And
we definitely need to help facilitate the land swap. So it definitely can be discussed.
I mean, if the Rotary folks asked you to come and talk about what can be done about homelessness in East Redmond, there's a whole lot of things that can be done. We mentioned some of them, the Oasis Village, the other 10 acres, something can be done on the 45 acres. I still think that since this is land exchange is of great interest to the fairground, the Fair and Expo, they should be at minimum considering, offering some space for safe parking there. There's a lot of things. So I just want to emphasize, if you want to talk about your specific idea, you describe it as your specific idea that has not been vetted with the board yet. and one idea among many for how we respond to homelessness in East Redmond.
And that's exactly where I'm at. So it's really interesting to get to I mean, it feels like there's tension on this, but it's just an idea. So I don't understand.
Well, if you push and plug one idea, and you're not talking about the other ones, then it gives people the impression that it's the main idea that is being moved forward in community.
Okay, so yeah, as I say, I've attended the Oasis huddles with the new mayor, we are referring to this last year. I'm fully engaged with all the service providers and partners that show up at all those meetings, and I've been doing it all year long. So I'm fully informed of the big picture, and I do this in light of Oasis Village moving forward and, you know, the request, and we've all signed off on a lease. So as I say, I mean, I'm taking offense that I'm not looking at a big picture. I am the big picture. No. So
You are the big picture.
I have the big picture there, and I'm always going to speak in that context.
Well, again, the idea that you want to speak in depth about is your idea that has not been workshopped with the full board of commissioners, with community partners, and
Yeah, so I don't
Could we,
understand what that means. I don't understand.
We are coming back at 1:30. So
Yep.
could we adjourn now and then we'll
Okay.
come back at 1:30?
So, yeah,
That would be great.
I mean, does that help? Because you,
I have a follow-up question, but if the board.
We'll do it later. Okay.
We can talk about it under other items.
thank you so much. We're going to reconvene at 1:30 today.